In view of the discussion made herein above, I am of the considered view that the impugned decision and order dated 16/5/2020 and 10/6/2020 are unjustified and not sustainable. Accordingly, the impugned decisions and orders that is so and so are hereby set aside and caused. Consequently, all the orders, including cancellation of appointment orders, are also set aside. And the petitioners are entitled to be reinstated in the service as teachers of LP and ME schools in the district of Nalbari in terms of the selection and appointment made pursuant to the advertisement dated 28/12/1996. Accordingly, the respondents are directed to reinstate the petitioner in their services without back wages, following the principle of no work, no pay, however, with seniority and other entitlement as may be permissible under the law.
Item 36, WPC 7805 of 2022.
Rate petitioner is not maintainable. However, the petitioner may avail the appropriate remedy that may be permissible under the law. In the event an appeal is filed by the petitioner, the time consumed in this present proceedings may be excluded for the purpose of limitation.
Any mention?
Wait, please, Lordship, with the due concern on the other side, Lordship, I beg to mention item number 19, 20, 21, my lord. In item 19, in item 20 and 21, we have filed our affidavit, my lord. In item 19, my lord, we have received our paravise, my lord. So we'll be filing it, my lord. So Lordship can give us 2 weeks time, my lord. I've taken the consent, my lord.
Yes. On the prayer of Mr.
A. Fukan, my lord, for the
A. Fukan,
GAD, my lord.
Standing Council GAD. 3 weeks time is granted to file affidavit. In WPC,
My lord, in the item 19,
633 of 2025.
Hello.
Rest you have filed.
we have filed, my lord.
Kindly fix a date on
Mr.
17.
So-and-so, learned counsel for the petitioner is present. 3 weeks.
Yeah, please, Lordship.
Yes.
But with the consent of the other side, I beg to mention item number 28, Lordship. Conducting counsel, Mr. A. Sharma has some personal difficulty today, Lordship. And it gets on for the day, Lord.
You're for?
Order number 228, Lordship.
For the petitioner.
For the petitioner.
On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. S.N. Sharma.
Yes, Sharma.
S. Sharma.
Yes, sir.
S. Sharma. You are appearing for?
228. Respondent number 228. I'm appearing on behalf of Mr. A. Sharma. S.N. Sharma was replaced by Mr. A. Sharma
A.
as
Sharma.
standing counsel.
S. Sharma. Respondent number 228. Please this matter and prayer not being objected to by learned counsel for the petitioner. List this matter after 3 weeks. And a date. We'll see.
Hello.
No problem.
May it please your lordship, I beg to mention for urgent listing of 2 rate petition, lordship. Urgent listing of 2 rate petition.
New,
Mass of bless.
May it please your lordship, with the consent of the other side, I beg to mention item 30, my lord. Lordship, in this matter, my lord, BTC was directed to obtain records, my lord, produce records, but the records could not be traced out. Sir. My lord, may give us some time, my lord.
okay.
I am for the respondent number 7 here, madam. Little urgency is there. Any date may be fixed.
On the prayer of
B. Bora, my lord, for BTC.
Learned Council, Standing Council BTC. List this matter after
After 2 weeks, madam.
2 weeks. So as to enable her to produce the records.
Yes, ma'am.
Because my lord, this record earlier. one,
Mr. So-and-so learned council petitioner is present.
Earlier, this record was produced before this honorable court. by
Okay,
Mr.
if she
Chief
doesn't have that. we'll
Any
ask
day
them.
maybe, my lord, because there's a urgency, my lord.
What urgency?
Because I am the promoted headmaster, my lord. And now the in-charge is occupying the post.
Hmm?
The in-charge headmaster
Hmm.
who was holding the post,
Ah,
but she's still there, my lord, because I am the newly promoted headmaster.
ah.
They are not allowing me to charge the headmaster.
There is stay.
Status quo was there, my lord,
So,
in favor of the petitioner.
okay,
And for the
we'll
rest-
see.
Of it.
May I please, your lordship? Lordship, I beg to mention item number 1, 2, 4, and 16. I'm the respondent and I represent the bank. I used to represent the bank, my lord. My lord, I'm no longer in the panel. However, my lord, the new appointment in the panel, a new appointment for the advocate of the bank is
Yeah, this-
being undertaken, my lord.
You have taken, you have made that submission last occasion also.
Yes, my lord, but a new council is yet to be appointed, my lord, because the last case came up on 26th. And today is second. They could not finish it in this short span of time, my lord.
Item 1, 2,
4 and 16, my lord.
4 and
Well,
6.
some difficulty is this, well, they are retired persons, except item number 2, rest 3 as a retired person, they have not been given the retirement benefits. my lord.
January.
My lord, can it be
My lord,
just before the vacation, my
No,
lord?
it's not possible.
in the first week of January, my lord.
First week.
Will your lordship please to fix a date, my lord? And these four matters, my lord, may be tagged together.
Then you read MS
Yes, that's my.
is thus. Learning Council submits that the respondent bank
Yes, my lord.
is under process of appointing new panel, a new council, new council for the respondents, which may take few days. Therefore, press that these matters may be this matter may be listed after 3 weeks.
Well, we fix a date in January,
Mr. M.
H amount.
HMO Learned Council, the petitioners is present. List the matter along with her, item 2, 4, and 16.
I am appearing for the corporation department, Lordship.
So and so
MD Bora for corporation department,
are present.
all this matter.
My lord, what I sincerely pray, my lord, if lordship add one sentence on next date fix,
Ah.
on the next date, my lord, this matter endeavor shall be,
It's okay,
Yeah,
we'll
that's good.
see, we'll.
my
decide
lord,
it.
my lord,
If
on the
parties are
grounds
ready,
that
we'll-
they are, no, on the ground that the bank has not appointed a council, my lord, this matter is suffering, my lord. That is why, my lord.
It's okay,
If lordship, one sentence of that observation, my lord, they will do it early.
no point. We'll take it up, we'll
Lordship,
dispose of the matter if they are ready. Huh?
My lord, may I fix, pay for a date, my lord, in January,
That's it.
6th and.
Obliged.
Much obliged.
6 January.
Item 3, no, item 3. Item 3. Right, please, your lordship, the matter relates to, my lord, correction of age. My lord, the petitioner passed HLC in the year 1984. His date of birth has been recorded wrongly, my lord. It ought to be, actually, my lord, the correction is like this, my lord. His date of birth has been recorded as my lord,
1966.
My lord, recorded as 1/10/1966, and it put to be corrected as 1/4/1968. So my lord, I filed a representation before the concerned headmaster, my lord. And headmaster, my lord, kindly have a look at page 13.
Where is your certificate?
HLC certificate, my lord. HLC certificate, kindly have a look at page 11. So his date of birth is 1/10/1966,
This was issued in 2012.
2012.
How come?
The duplicate pilot.
Huh?
The duplicate pilot. He appeared SSLC examination 1984. He was given the certificate. Now this is a duplicate certificate.
Where is that?
The Lordship kindly see top.
Was the high school living certificate exam 1984 of this board and was placed in the.
Duplicate certificate can be issued, my lord, later.
Duplicate
Duplicate
can be issued.
duplicate certificate can be issued later on. If the concerned person does not have. There is a provision, my lord. So the grievance of the petitioner before your lordship is.
Where is the provision?
My lord, if someone does not have suppose I have lost my original certificate issued in time.
Yes, you
So
said,
thereafter
you said there's a provision. So what's the provision?
My lord, I have taken also my certificate, or I have lost. I have collected all duplicate certificates by applying fees,
What is the,
applying petition and fees, giving fees. So my lord, my grievance is this, my lord. Kindly have a look, page 13. I have the honor to inform you, prayer for correction of date of birth. Sir, I have the honor to inform you that I passed SLC final examination in the year 1984 from Buragaon Horicharan Sarkari Higher Secondary School. But mistakenly, my date of birth has been recorded in admit card of 1/10/1968 instead of 1/4/1968. I therefore pray that you may kind enough to correct my date of birth in my HLC admit card and original certificate. And this is my humble prayer to you.
when it was filed?
I filed before the principal.
When?
I filed it, my lord, principal forwarded 8/2/1997.
97.
My lord, date of birth, what principal says. Note, kindly see the note. Date of birth has been recorded wrongly as on 1/10/1966. But according to our school record, it is 1/4/1968. Hence, it is forwarded to the respected Secretary Shiva for his kind information necessary action.
What is your earlier this thing, certificate?
Page 11.
This is 2012.
Where Mola duplicate certificate issued on 2012.
That's just.
Original issued in 1984.
Where
He
it
has
is?
come before your court, my lord, after 40 years of passing the SSLC examination.
Let me submit.
And he joined in the service, my lord, thereafter. And belated state, my lord, he is going to be retired next year, February. So in a belated stage, my lord, court would not interpret this correction of date of birth. In fact, there is no wrong in recording his date of birth in our official record. We have filed an affidavit, my lord.
What is the law on it? What is the law?
Which law, my lord?
So far the correction of date of birth is.
My lord, your lordship, please complete the argument. Hear me for 5 minutes. I have come some documents to show your lordship
I
certificate.
have seen your all the documents.
No,
Where's
my
the-
lord, my
you
lord.
have few documents.
Kindly see my date of birth certificate, page
Yes.
15. Kindly have a look at page 15. Let me complete my argument, my lord, then your lordship will assess. Date of birth is 1/4/68. My date of birth says 1/4/1968. My lord, thereafter, kindly have a look at page 17, what the school inspector said. School inspector made a thorough inquiry on the records of his admission register. What is his note? Kindly go through it. My lord, school inspector says, correction of date of birth of Muhammad Said, so and so ex-student of Buragaon Higher Secondary school thereof. Sir, with reference to the subject cited above, the owner to state that Muhammad Saidur Rahman Sons, ex-student of Buragaon Horicharan Sarkari Higher Secondary School, and appeared the HLC examination 1984 under roll so and so. His date of birth was wrongly shown as 1/10/66. In this connection, I physically verified the admission register of Buragaon Horicharan Sarkari Higher Secondary School and found the age of Muhammad Saidur Rahman, age on 12 years, 10 months, 11 days, on the date of admission on 12/2/1981. Hence, his actual date of birth as on 1/4/1968 instead of 1/10/66. So this is the finding of inspector of schools. He went the school and verified his admission register and calculated the date of admission, date of birth, and found that at the time of examination, his date of birth would be 1/4/1968, not 1/10/1966. So he has sent a copy to the Secretary Seva for correction of his age. And school inspector is the final authority of a district concerned in education department. Thereafter, my lord, I have filed a fresh representation.
Lordship, before he.
Let me complete, Mr. Chetia, let me complete. You will
have a search.
at the time of your argument, you will
I
have.
am wasting the time, my lord. I am before showing the law. As per law, my lord, in the commencing of the year of the examination, within 3 years, he has to apply for the correction of the date of birth. And beyond that, cannot. The detail. And he has come after 40 years of my lord, passing this year. He is going to be retired next year, February. So what is this, my lord? There is no wrong in the recording in the date of birth of his, about his. There is a law, regulation is there. Correction of date of birth.
Yes.
So,
My lord, let me argue. My friend intervening the matter during my argument.
No, no, I am.
He is at- let me complete
I
my-
am showing the law.
Yes, let me complete. You will show it during your argument. So, my lord, thereafter, I have submitted the matter before the school inspector. The school inspector verified the spots, recorded the documents, thoroughly examined all the documents and found that my date of birth would be 1968, not 66. That was pending. Finding no alternative, I have filed again a fresh writ petition, my lord, annexure, page 18. Kindly have a look at page 18. My lord, to the secretary, so respond number 2, prayer for correction of date of birth 1/4/1968 instead of 1/10/1963. Letter dated 33/19/1990 sent by Assistant Inspector Vilsus Morigaon, District Morigaon, Assam. I referred the matter. With reference to the above, I have the honor to inform you that I appeared the HLC examination in the year 1984 under so-and-so. My date of birth has been recorded wrongly as 1/10/1960 instead of 1/4/1968. And in this connection, I submitted a prayer petition for correction of same through proper channel as referred above, but the same is still pending in your office. Now, sir, being aggrieved, I do hereby submit a fresh representation for correction of my actual date of birth as 1/4/1968 instead of 1/10/1960, and my date of birth is also indicates that I was born on 1/4/1968. Therefore, your honor may kindly be pleased to correct the same in an early date for the interest of justice and policy. This is my first petition. I have submitted on 1/2/2022. So, my lord, for the answer of justice, my whole representation from the beginning to end to the fresh one is pending before the authority, my lord. So, why not my case should not be considered, my lord?
See, you have the first application you have filed in 1997.
1997, yes.
Then
Then, my lord, 1997, then thereafter, my lord, I have submitted on 33/1998 to the inspector of school. Annexure 5, page 7, my lord, kindly have a look at.
see, when you filed this application in 1997, where is the death certificate?
That certificate is my original record. It is in the board, my lord. That certificate, school is principal of the school sent a letter. I have submitted the petition before the principal of the school. Principal of the school sent the letter to the SEBA, secondary board of education,
It's
along
okay.
with my original petition.
Before that, when you submit this application, this page 13,
Page 13,
yes. No, not this.
page 13, I have submitted to proper channel to the principal.
Yes, then,
Then, my lord, then again I have gone to the inspector. And inspector forwarded a letter to the respondent number 2, secretary, stating interior details, the grievance arises.
1998.
Yeah.
Then,
Then, my lord, finding no way, I have filed a fresh application again on 1/2/2022.
what did you do since this 1992 to 2022?
Now I am a school teacher, my lord. I am a school teacher.
So,
I filed my appointment letter also.
so, and you obtained the certificate in 2012.
Which certificate?
This, your certificate.
HLG certificate. I obtained, I lost my original one, I obtained it, that is, my lord, whatever certificate, when the second time certificate issued by the SEBA, in the above, it is usually written, it is their official system duplicate. Suppose, if I supposed to collect a certificate
no.
now, it will be duplicate.
Please, your appointment was of 1996. 97, you write a letter to Secretary Board of Education, Assam.
Yes,
The authority to correct your date of birth.
date of birth, yes, she is the authority, if there is official mistake. If headmaster does mistake, my lord, if headmaster does
No,
mistake.
I'm asking. I'm not questioning you. I'm just asking whether the Secretary Board of School Education is the authority to correct your date of birth in the service book.
Not service book, but in certificate.
Huh.
But certificates, I'm not speaking about
Where is that certificate? I just wanted to know.
which certificate, my lord. I have certificate, I have annexed.
If this certificate is of 2012, when you came to know this is wrongly been recorded, wrongly been shown in your service book, right?
Yeah.
In 1997,
Yeah.
you filed an application,
My lord, my lord.
secretary.
Earlier, I did not look into that. So,
No, 96 you are appointed.
yes,
97 you filed an application that my date of birth should be, this birth should be corrected, right?
yes.
On what basis you have you have asked for correction? Any documents, any certificate at that point of time?
No, I went to I have gone after getting my appointment. I've checked my documents, I've seen that my certificate has been issued wrongly.
That's what I'm saying. When you
So I went to headmaster for filing a petition, my lord. Without proper channel, I must go to proper channel.
That's what I'm saying. Any documents to show that at that point of time, 1997, 98? Any documents?
What documents, mate? I don't understand what document.
Certificate, school certificate, birth certificate, whatever.
What certificate, whatever school inspector.
You simply said that it has been wrongly passed in 1984, recorded admit card instead of so and so, so and so. Date of wrongly, my date of birth has been recorded in admit card as on so and so instead of one so and so, so and so.
So,
Right?
so,
Then what basis you have, what is any certificate you have submitted along with that?
my lord, kindly have a look at inspector statement. Inspector statement.
I'm asking, did you submit any certificate at that point of time?
I do not know whether I have submitted at that time. Why?
You must know, it's your case.
I do not know what any documents he has submitted before the school headmaster. Firstly, I have filed a representation before the headmaster to correct it. Headmaster sent the matter verifying his register to the school inspector address, to the respondent number 2. Thereafter, went to school inspector.
Yes.
School inspector said, I examined physically the school records, admission registered, and found that at the time of admission, his date of birth is so and so. On calculating that, it is seen, it is found that his date of birth was 1/4/1968.
Hmm.
Your lordships, on what basis it reveals on the report of the inspector? Kindly have a look at page
Read
70.
it.
Kindly have a
I've
look at.
read
page
it. I have seen it.
I physically, my lord, kindly see. My lord, on 4. In this connection, I physically verified the admission register of Buragaon Horicharan Sarkari Higher Secondary School and found the age of Muhammad Sanso as on 12 years, 10 months, 11 days. This is the basis, what your lordship sought. On the date of admission on 12/2/81, hence, his actual date of birth as on 1/4/1968 instead of 1/10.
There is no point reading
So this is
again and
this is
again. I
the
have-
inspection report
seen
of
it.
the inspector. And he is the school authority in the district, concerned district. Annexure 5, page 17 is very much proved. My admission register, my date of birth, what inspector stated. It is the inspector letter, my lord, official letter. His seal and signature is there. On the strength of this letter, your lordship can direct the authority to dispose of the matter. I physically examined, he said.
Yes. Have you filed any affidavit reply?
I didn't file a reply to the affidavit submitted by my counsel.
Then
I did not file my.
they have annexed these documents.
Yes.
Original documents. Not only about you, all the students. 91 students.
Okay, my lord, if affidavit, then I shall file the affidavit giving my original documents on what basis my date has been calculated,
What he,
date of birth, etc.
what he will file, my lord, he cannot deny.
I'll
this.
file affidavit, if
He is
necessary.
not denying it. This is a school
So
record.
you have the copy of the affidavit.
Have.
I don't have now, along with me, I don't have.
Do you have the affidavit?
No, much
Copy,
like.
have you not been served with the copy?
Yes, we have served without serving the copy, registry do not allow us to file.
I do not have any affidavit.
Sir, I believe it, the cases cannot be one-way traffic.
What?
No.
We have given them a chance to file an affidavit. to
Oh,
respond. They
my
are
lord. That is nice, my lord.
on your petition you are arguing.
No, my friend is telling.
You
that-
must know what is their stand.
Understood, but he is telling
For
about
disclosure-
3 years, 3 years, after 3 years, the one cannot hammer on the Lord, but
It's not only
Yes.
that.
my lord, Supreme Court judgment is at my
See,
hand.
record, they have annexed the records.
Okay, they have given me a copy, they have given me a copy, I have gone through.
Yes.
But I thought that it is
disputing
not,
this?
no need to file affidavit because Supreme Court judgment is there
I-
on
you-
this.
Are you disputing this? School record? It's not only about you, it's all the students recorded at that point of time.
As
Which year
per
this is?
Nasim Banu,
1984.
as per Nasim Banu case, whether he is not controverting our contention, it is presumed to be admitted.
Sir, let us come to the facts.
My lord, one thing, your lordship may do,
Let us clear the
let me have
facts.
the opportunity to file affidavit. On their affidavit submitted in total, in concert.
Oh, he
They have
got-
given me the copy of the affidavit.
he got the affidavit about.
Whether you file it or not.
I've gone through, but I think I felt that no necessity to file an affidavit because
Why?
my.
When they are relying on the documents, school documents, are you disputing? If you are not disputing, we'll just not go on the letter written by the authority.
My lord,
The
in
record
their-
will, if the records speaks otherwise, why should go rely on the
by the
even
code of
by the
sanitary,
authority?
what affidavit they say, they have given me copy. But here, what was the date of birth? It should be sorted out. What was the date of birth? I'll file an affidavit, my lord. I will file an affidavit showing my date of birth.
Date of birth is 01 1st October 1966,
Let me see.
page 22, page 25, 25.
Date of birth,
Page
here,
25,
date of birth,
serial number 89.
yeah, I found 1/10/1966. It is date of birth, that date of birth I am challenging, my lord. It is my dispute.
Huh?
This is my dispute. So actual date of birth, what inspector said, inspector did calculation of his date of birth, he found that it should be 1968.
Has it been
So it is wrong.
corrected? Has it been corrected?
That, my lord, that.
Has it been corrected?
It-
Has the record been corrected? Board of Secondary.
No.
It has not been corrected, yeah. So
Who has
for
issued
correction, I have come before
Who
you.
has issued this certificate and all these letters? Are they still in the job?
No, my lord. We have
How
not
is it
received
inquiry?
any representation from
Sir,
either
it's
from the
not-
inspector
It's,
from
the-
the.
it's not as simple as it is. Maybe your age may be 68, right? We don't know.
Okay.
But then school records shows not only yours, all the students that point of time, they have annexed. It shows the 66. Unless this is corrected, right? Unless this is corrected, authority can, on your asking, how can they issue the letter? Just because calculating your age, that was the, I mean, that will be chaos. This cannot be permitted. Cause an inquiry. Are these the officers who have issued this letter and the certificate is still in the job? In the
Which certificate,
service,
my lord? Which certificate?
which they have relied? The principal
It's no, we have not received,
And-
my lord. We have stated here,
and the
our,
inspector of
No, no.
school.
we have denied it, my lord. We have stated in our affidavit. No, we have not
The
received anything.
Principal in 1997
No, my lord.
and just wait. And the director,
Our paragraph 7, lordship kindly see. Anything, my lord. There is a procedure. He has to apply paying certain fees and through proportional. But he has not sent it like that, my lord. And that too within 3 years from the date of commencing the examination. Lordship kindly says, paragraph 7, the deponent begs to.
I have seen it.
No. He just come to,
Your authority themselves have issued a letter, inspector of school.
it did man by authority, it is the education department inspector is different thing. We are, I on behalf of the board.
You,
On behalf of the board, my lord.
the part of it only. You are
No,
not
my
getting-
inspector is a government servant and.
Who is appearing for inspector? Are they party here?
Education department, my lord.
Are they party here?
Oh, my lord, he
Is not made
not a
part.
necessary party because school actually
Commissioner.
under the inspector.
No, my lord. He has not been made party.
Okay, education, elementary education of Commissioner Secretary, Education, Secondary.
School inspector is
Who
not
is
required
appearing
to
for
be a
this
party.
education department?
Education department, my lord. There should be.
First,
This one
you
secondary.
have to correct their
Yes, number one,
the
secondary.
documents in the school. Principal cannot just write that.
Log name
like
to
that.
education officer.
He should have first
for this-
get the documents, I mean, school records corrected. If it is really 1968. It appears that you just ask them and they have just written it.
True.
And that will be it will have a serious consequences.
He has come to court only to extend his age, my lord.
And I don't know whether 66, 68, but the school record shows that it is 68,
68,
right?
yes.
Sorry, 66. And on your mayor asking the principal, inspector of the school, authorities, they are writing without correcting the record. if that is true, if the principal and actually if it was true, the inspector of school, they should have corrected it on the basis of their findings, whatever. It appears to be something fishy.
Now, my prayer to get it corrected on the basis of the inspector letter.
You have not get it corrected. They have just simply written on your application and a letter. First, maybe they might have verified. On the basis of verify, it has to be corrected. How the authority will know?
So letter of
Mr.
inspector is
Tunda,
not.
another issue, you have issued the certificate in 2012. Who has issued this? You are put the board?
1984.
No. This
It is
phase 11.
Duplicate is 12.
Who has issued this?
It's correct. Duplicate is correct.
Okay.
But in original certificate were issued in the 1984 when he appeared in the SSLC examination year 1984.
Okay, this page 11 is correct one,
Yes.
Correct.
2012.
Secretary
Duplicate
registered.
is
signature
also
is-
correct. Can be issued by a duplicate when it
So 10-10-66, this is.
66. Well,
Uh,
on the basis of he joined in the service 1996, and now he is a flag end of this career. He has come to the court that my age is should be 68 instead of 66. How it is possible? Ketana decision is there Supreme Court. My lord says, my lord, in the court has held that even if there is a good evidence to establish that the recorded date of birth is erroneous, the correction cannot be claimed as a matter of right.
My lord, inspector says on the basis of the admission register and date of birth, what he has stated. I'm hammering on that. Why the inspector letter has
are
been
you-
shown up? Why
Are
it
you
has not been
denying this
considered?
record?
That is that I have gone through, my lord.
This is the record.
Record says 166. And I want to get it corrected 1968 instead of
How?
66.
On what basis?
On the basis of the inspector letter. What I submit before your lordship, an inspector of schools, I said, I physically examined
So
and found so.
the assistant inspector of schools, whether they do the prayer call
It is
by
my
the-
prayer before your lordship.
and that letter is not received by
What
the.
more documents I want? That's enough, according to me. According to me.
Heard Mr. So-and-so, petitioner. You produce the record, original record.
What is, my lord, I have an annex here, my lord, I can
record.
produce it.
Let's see.
This is a, my lord, this also, my lord, attested by the officers, my lord, not if you can receive.
No, get the original record.
Record, I will have to bring the volumes of book, my lord. Okay, my lord. I will
Bring
do
it.
that. Day after tomorrow?
Any day.
Yes.
I will file an affidavit
Yeah.
regarding my age, date of, regarding my other documents, affidavit, this and that, if something else. In support of my date of birth. So my lord, after vacation, January 1st. I'll file an affidavit.
Friday,
This Friday, my lord, I will not be here, my lord.
then
This Friday, I will not be here. My lord, let me.
I will produce the original record, my lord, Friday only. Yes.
Friday, I will not be here, my lord.
Whether you will check it, you check it.
No,
whether you-
Friday, I will not be here, my lord.
Oh.
So fix the
Let-
date,
next,
first week of January, my lord.
next Tuesday.
First week of January, I will file an affidavit.
Sir, we cannot just do like this.
Okay.
When the things are little going against you, you just cannot take adjournment. And you have left over. When did the affidavit was filed? When I pointed
Long
out,
back,
you
long
said,
back.
you have decided it's not required. Then we'll accept that.
My lords, and so nature just admissive flare away, my representation are pending. My lord, my latest representation last part is also pending. Your lordship may dispose of the matter, directing the authority may consider, may not consider. Directing the authority to dispose of my representation.
Hello, we have filed affidavit 28/9,
It is-
2023.
Annexure 6 is pending. If they do not consider, I will go to, I will think for another things. So your lordship may dispose of them by directing the authority, respondent number two,
Not that easy.
to dispose of my
We
representative.
have no
Yes,
receipt
something
with us, how
fishy.
possible direct it?
There's something wrong. I wanted to go to the root of the matter. This cannot be allowed. Therefore, I'll hear you. As much as time you want, I'll allow you and we'll decide the matter. This cannot be permitted, right?
So my lord, let's
This
shoot
is
after,
something which we cannot.
let's shoot after 4 weeks, my lord, I will file an affidavit. Giving counter affidavit to my landed friend, what he has submitted, I will
Anyway.
file a counter affidavit.
As agreed to by learned counsel for the parties, as agreed by the, as spread for by learned counsel for the petition, list this matter on January 6th January.
6 January.
6 January. Deeply obliged. Your lordship.
Mr. This
Yes,
is
sir.
learned counsel for the board to produce the original report.
Obliged.
Have a talk with your, the petitioner.
I'll have a talk, my lord. I'll have a talk.
He might,
I will
let
collect
him-
all documents.
let him reflect.
My lord, I will collect
Right.
all documents to satisfy your lordship.
I am granting, I am indicating you. Tomorrow, they say no. लेने का देना न पड़ जाए.
My lord, it is correct, actually correct. I'll
There's
show
something,
my documents.
something wrong. Have a properly talk with your client. I had some doubt. I'll not tell you. You find out. There's something. Since I am not disposing of the matter today, there's something. Look at the records, your records.
Okay, I shall make inquiry on that.
Better to have a peaceful retired life instead of we लेने का देना पड़ जाएंगे. Right? Thank you.
far as this matter is concerned,
Yes.
both of us ready for hearing. In fact, on last date, Lordship, another bench almost extensively heard this matter. Today, I was only supposed to place certain citations, Lordship.
Not by this bench.
Lordship,
Not by me.
not by your Lordship.
Then how do you know?
That is what I am submitting, Lordship. You know, my friend has no objection, Lordship.
No, my lord,
Objection in
the
that.
last order does not reflect that the matter is part heard. And the
That is not reflected.
roster has already changed. And my lord, some urgency because 19 months of suspension, prolonged suspension amounts to a punishment, my lord, take that order of punishment. So my lord, lordship will kindly take up the matter.
Today?
Yes, ma'am.
Okay. No issue.
Last it was taken up on 28. So the order does not reflect this part heard. And the roster has changed and as per roster, it has come up before this honorable court and lordship can take up.
No, if you have any objection, we'll place before the appropriate bench.
So
I
otherwise, my-
submitted, Lordship. If he has objection, I'm ready with the matter, Lordship.
let's do it, ma'am.
No, if you have more comfortable, if the matter was heard, we'll place before the bench.
But
There is no
since
question.
Roster has changed, now that coordinate bench is taking criminal bench, my lord, I have to again wait for the roster to change, my lord. And the order does not reflect it is part heard. 28/11/2025 order.
Yes.
Yes, may it please your lordship.
Hmm.
My lord, the petitioner was suspended on 10/4/2024, now 19 months going on. And my lord, the show cause notice was issued on 26/4/2024, that is within 3 months. However, my lord, as your lordship knows, as per Ajay Chaudhary and as per OM dated 4/2/2020, issued by the government of Assam. Even if the show cause notice is issued within the period of 3 months, then also a review extending the suspension order is required, which has not been done in this case. And after filing of this writ petition in last November, they have started reviewing, my lord. So, my lord, I humbly pray that this honorable court will interfere with the suspension order and reinstate the petitioner in service. Lordship will kindly turn to page 28, that is the suspension order, your lordship. 28 of the report.
Yes.
20, not 28, 20, Annexure 1.
Yes.
Yes, it's order dated 10/4/24.
Yes, you're, we're placed under suspension.
Yes,
After
placed.
the arrest.
After arrest in connection of ACBPS case number, my lord, 27 of 24.
Yes.
Yes.
Then,
Then, my lord, thereafter, so-called notice was issued. In the meanwhile, the competent court granted the appeal. And my lord, the so-called notice was issued on 26/4, that your lordship will find on page 29, Annexure 4.
you are arrested on,
My lord, I was arrested on
18/3,
18/3/2024.
23.
24. In connection with ACBPS case number 27 of 2024.
yes.
Yes. Now thereafter, my lord, I submitted my reply to the so-called notice and participated in the departmental proceeding. However, my lord, as your lordship knows, as per the law governing the field, my lord, the authorities are required to review the suspension order within a specific period of time that they did not do. And after filing of this writ petition, they got wiser and they started reviewing, my lord. And this honorable court, as well as the honorable Supreme Court in Deepak Mali's case, has categorically held any subsequent review beyond the prescribed time is of no consequences, my lord. So, my lord, lordship will now kindly turn to page 41, Annexure 7, that is their own OM.
But the memorandum was filed within time.
Within that, yes. Yes. Memorandum was within.
Your only grievance is that, after the filing of the, submitting of charge sheet or the memorandum of charges,
Yes.
even if memorandum of charges,
Is filed within time, then also a duty is cast upon them to review the suspension order and extend it by,
within how many?
my lord, in Ajay Kumar Chaudhary, as per Ajay Kumar Chaudhary, it should be within 3 months. However, my lord, subsequent to that, Government of Assam has issued an OM, lordship will kindly turn to page 41 of the writ petition, Annexure 7, page 41. This is very important, my lord. May I read it, my lord?
The senior most secretary shall undertake a review within 6 months.
Yes.
As regards the desirability to further continue with the suspension order.
And the senior most secretary will be held responsible. That means a penalty has been prescribed. So it is mandatory, my lord. As your lordship knows, as per rules of interpretation, when any penal consequences
The
are.
charge sheet was filed
Charge sheet was filed on 26/4/2024, Annexure 4.
26/4/2020.
Suspension order dated 10/4/2024.
So no issue. Then review?
And first review, my lord, lordship will kindly take up their affidavit in opposition. First review on 6/12/2024. 6/12/2024. Beyond the prescribed time limit. Then, my lord, subsequently, the second, third, fourth review has been done, but in my humble submission, since the first review itself is beyond the prescribed time limit, the same is of no consequences, my lord, as per held by this honorable court as well as the honorable Supreme Court, my lord. Lordship, in this context, I would like to first place the judgment of Ajay Chaudhary, my lord.
This is what?
It's there, my lord.
This is by you,
Yes.
Diganta.
Now, Diganta, I'm relying, but first Ajay Chaudhary, my lord.
It's okay, Ajay said you.
Yes.
Just give that.
In SCC, my lord, it is para 21. However, here it is para 14, my lord.
Yes, it's okay.
Yes.
Where it is Diganta is where?
Yes, Diganta, my lord, because now the respondent will like to contend that in Ajay Chaudhary and para 21, there are two parts. First, if the show cause notice is not filed within, my lord, 3 months.
It's not the case here.
Now the second part is, my lord, that if the show cause notice is filed, which is in the instant case, then what is the time limit prescribed? So, my lord, let me place Diganta, my lord, their contention. Lordship has the Diganta Kavita judgment, my lord. It is reported in 2024 for GLT 1007. Lordship will kindly turn to para 10, 11, and 12, their contention, my lord. May I read it, my lord? Mr. Nayak, learned standing counsel Public Works Department, by referring to the decision of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary Supra, more particularly paragraph 21 thereof, has submitted that the time frame as mandated therein for currency of a suspension order at 3 months is for a situation wherein the memorandum of charge sheet has not been served upon the delinquent officer employee. He has further submitted that the Honorable Supreme Court had not laid down any time frame for review of the suspension after issuance of a memorandum of charge sheet within 3 months so permitted for currency of a suspension. Now, my lord, Lordship will kindly turn to para 22 of the judgment, my lord. These are the contentions recorded, para 10, 11, 12. Now, para 22. Lordship, 1, 2, 3, 4, 6, 7, 8, 9, 10, 11. 12 line from the top, my lord, coming to the second part. Has your lordship got it? Coming to the second part of law. Has your
Yes.
lordship got it? Yes. Coming to the second part of law as laid down by the Honorable Supreme Court, that is, if the memorandum of charge sheet is served, a reason order must be passed for extension of the suspension. This part of the law as laid by the Honorable Supreme Court has to be read in conjunction of the first part, that is prescription as made for currency of a suspension order, that is for a period of 3 months. Accordingly, understanding the law laid down by the Honorable Supreme Court in the manner as noted above, it is to be held that if a memorandum of charge sheet is served upon the delinquent officer employee within a period of 3 months from the date of his order of suspension, for an extension order of the order of suspension, a reason order must so be passed. However, as to when such order extending the suspension is mandated to be issued would be dealt with later on in this order. Now that discussion has been discussed at my lord, para 29. Lordship will kindly turn to para 29 of the judgment. Yes. It starts the law as laid down by the Honorable Supreme Court. The law as laid down by the Honorable, has your lordship got it? Yes.
Yes, sir.
The law as laid down by the Honorable Supreme Court would therefore mandate that a suspension order being issued, the currency of the same would not extend 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. The second part of the law mandates that if the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension. The second part of the law declared by the Honorable Supreme Court cannot be read in isolation and has to be read in conjunction with the first part. Accordingly, it is to be understood that the currency of an order of suspension, while not being permissible to be extended beyond 3 months from the date of its issue, if a memorandum of charge sheet is not served on the delinquent officer employee, and, my lord, this is important, and if a memorandum of charge sheet is so issued within the period of 3 months, the same must necessarily be accompanied with a reasoned order extending the order of suspension. So, my lord, this honorable court has held that even if the memorandum of charge sheet is filed within a period of 3 months, as mandated by the judgment of Ajay Chaudhary, then also the extension would be, my lord, has to accompany with the, my lord, charge sheet. This is the finding of this honorable court. And
There
yes,
should be, suppose if it is the charge memo is filed
yes,
within 10 days,
yes.
and the review has to be within 90 days with reason.
No, my lord, yes, review has to be within 90 days with reason. Because the 3 months period has been prescribed by the Honorable Supreme Court in Azad Chaudhary at para 21. That is how the 90 days comes in, my lord. Even before Azad Chaudhary came in 2015, my lord. And if your lordship kindly take up the service rule, in 1964 service rule, it was always there, my lord. But that is 1964 service rules, my lord.
Is it said so that if the memorandum with charge is filed, it has to be reviewed within 3 months?
Yes, that is the finding, my lord.
No, in the service rule.
No, yes, lordship, kindly take, I'll just refer to departmental manual 2.1. It's there, my lord. 2.1.8 of department. 2.1.8 of the departmental manual of departmental proceedings.
Page.
In my book, it is page 59.
Point
1.8. 2.1.8.
Huh?
two point one point
8. Principal of interest regard to suspend and
May I read it, my lord? Small Roman 2.
yes.
Even if it was not practicable to file the charge sheet, then also 3 months' time has been prescribed, my lord, small Roman 3. In cases where it is reasonably not practicable to prepare the charges for service within 3 months from the date of suspension and continued suspension of the government is considered necessary in the public interest, the authority concerned should move the personnel department through administrative department well before the expiry of period of 3 months' time. So Roman 2 and Roman 3 in 1964 itself prescribes 3 months period, my lord, for suspension. Extension or review of suspension, my lord.
Hmm?
Roman 2 prescribes, my lord, 3 months period for
In case
extent-
where it is not reasonably practical to prepare the charges for service within 3 months. Yes, then three is.
2
what
and
is-
3, both Roman 2 and 3. 2 prescribes the 3 months period,
Ah,
and 3 prescribes if it is not, then also they have to, my lord, move well before the 3 months period to the personnel department. Am I clear, your lords?
in cases where it is not reasonably practicable
Yes,
to prepare the charges for service within 3 months
Hmm.
from the date of suspension, then the continued suspension of the government service is considered necessary in the public interest, the authority. Then it cannot, if it is not filed,
yes, No,
it
no.
cannot be filed within 3 months,
yes.
then only you'll have to move the personnel department.
Yes, yes, no, what I'm saying is that, my lord, this 3 months period of limitation, this is not for the first time that Azad Chaudhary has got it.
No, it's okay,
Ah.
but then 3 months time to, it's okay, it's not your case. Your case is that although the charge sheet has been filed within
3 months.
3 months,
Then also, as per now, OM dated 4/2/2020, my
then
lord.
say no, it doesn't have any relevance in that case.
My lord, no, I was just showing this rule for the period of 3 months.
No, nobody is disputing that.
Yes, right. Now, my lord, in this Diganta Kalika's case, as I have referred in para 29,
Hmm.
it says, my lord, even if the show cause notice is filed within the
It is to
period
be
of
understood that the currency of an order of suspension, while not being permissible to extend beyond 3 months from the date of its issue, if a memorandum charges is not served on the delinquent officer, and if a memorandum charges within the same must necessarily be concomitant with the reason order extending the period order of suspension. In other words, either on the date a memorandum charges it is so issued and on the date the same is served. This memorandum charges must necessarily be concomitant with reason order.
And para 30 also, my lord. Applying the conclusions reached herein above to the facts and circumstances of the present case,
Is so served.
it is an admitted position that neither on the date of issuance of so called notice dated 24/6/23 to the petitioner herein, nor on the date.
But here it says that it has to be not within the 3 months. It is said is that it has to be, memorandum of charges has to be accompanied with the reason order extending the
Yes.
suspension. That is what said. It doesn't say that it should be within 3 months.
No, my lord, because the memorandum of charge itself has to be filed within 3 months.
Yes.
So, my lord, if the review or extension has to be done, and if it is to be accompanied with the memorandum of charges,
This in Diganta's case, it said that it should be, the memorandum of charges should be accompanied with the reason order extending the
absolutely true, my lord.
suspension.
No dispute. But when the memorandum of charges is required to be filed within 3 months, then the same ratio will apply to the extension order.
If it is with the, say, in your case, it is 24.
Yes.
When it was served, it has to be accompanied with the reason order extending your
It was
service.
not there. And if it was not there, so within 3 months, there was no extension. And as per their own OM, 6 months, within 6 months also that was not there. It was beyond everything, my lord.
Yeah.
The first review was done in December. Para 30 of that judgment of the judge. Para 30, my lord.
Okay.
Para 30 of the.
What's there?
Yeah, to show that subsequent will have.
Neither on the date of issuance of so notice to the petitioner, nor on the date it was so served upon him. The respondent authority had not on a review carried out of the suspension order of the petitioner issued the reason order for the extension of the.
The subsequent extension as effected with regard to the period of suspension of the petitioner in view of the above noted lacuna would not have no consequence. So if after the prescribed period, my lord, even if they review it, it would be of no consequence. Here exactly same thing happened. Within 3 months, no extension, though charge filed. Within 6 months, as per their own OM 4/2/2020, that was also, my lord, violated. Now, after filing of the petition in the month of December, they have carried out the first review, which is beyond everything, my lord.
After or before, it's okay.
My
Whether after or before filing writ petition, it's not.
My lord,
It's not. There's
that is not meant, yes, that is-
consequential.
that is not meant.
So, even if it was not accompanied, say it was not accompanied
It is not
with
accompanied,
reason
admitted,
orders
admitted.
extending your suspension,
Yes.
but then could have been
Within 6 months.
within 6 months.
That also they, my lord, violated.
But here, beyond 6 months, they have reviewed for the first time.
For the first time, in the month of December. And suspension was in the month of April, my lord.
That's all.
So, my lord, I humbly pray lordship will interfere with the impugned order dated 10/4.
We'll examine, see.
And direct the petitioner. And my lord, one more judgment of division bench. This is important in the context of facts, my lord.
On what point?
On, my lord, prolonged suspension. To 19 months is going on, my lord. Just one paragraph I will read from the division bench. Page 444, 2014, 2019 5 GLT, page 444, my.
2024,
2019,
volume 4, or GLT 1007. Diganta Kalita versus State of Assam. And 2019,
5 GLT,
5 GLT, triple port,
para 15.
State of Nagaland versus Chuba Nungchang Imchen,
DB judgment, my lord, division bench.
para
15, 1-5.
para 15. Here para, here is, here, Diganta does para.
Diganta Kalta, my lord, for the facts, my lord, it's para 10, 11 and 12.
It's okay.
And my lord, para 22, 29 and 30.
22, 29 and 30. Then Ajay Chaudhary,
Ajay Chaudhary, para 21.
2017,
2015, 7 GLT 291.
2015,
7 GL, SCC 291.
291.
Mm.
Para 21. Yes, para 29, 21. Just write it down. Yes,
My lord, that division bench judgment 1 para 15, I want to place before your lord.
read.
Yes. My lord, same thing, my lord, same suspension order. It was not reviewed, and this honorable court division bench, while dealing with the order, the state government definitely has the power, authority and jurisdiction to keep a government servant under suspension pending trial of disciplinary proceeding, or during the pendency of a disciplinary proceeding, or during the pendency of a criminal investigation, inquiry or trial. The object of placing a government servant under suspension is to keep him away from the influential position wherefrom he can interfere with the conduct of disciplinary proceeding, pending or contemplated, or criminal investigation trial, so as to prevent him from hampering with the process of collection of evidence or tampering with evidence in any manner, or where, having regard to nature of charges, allegations against him, the competent authority is of the opinion that it would be unsafe to continue to vest him the powers of the post of government servant is occupying. It is for the competent authority to consider all these aspects at the time of placing the government servant under suspension, and also during the period of subsequent suspension for keeping him under suspension. And this is very important. At the same time, on the other hand, placing government servant under suspension for a prolonged period unduly would change the color of measure taken to place the public servant under suspension with the aforesaid objective into a measure of punishment. Now, my lord, in this case, the petitioner is in the 19th month of suspension. Departmental proceeding, I participated, no outcome. My lord, now HHM lordship knows, my lord, where incumbent is placed under suspension, so that he could not tamper or influence the evidence or a witness, my lord. Here, the departmental proceeding is over, they are sitting over it. They have not reviewed it within
Where is the
the
stage of departmental proceeding?
My lord, I submitted my so-called reply, and the inquiry officer was appointed and hearing was conducted. Thereafter, no communication.
It is at the cross-examination stage.
So, my lord, my humble submission is that, my lord, either way, my lord, this has to go, my lord. Lordship will kindly interfere and reinstate me in service, my lord.
We'll see.
Yes, your lord.
Yes.
Deeply obliged, your lord.
Now, so far as the facts are concerned, Lordship, dates are admitted.
Yes.
Lordship, initially he was arrested on 18/3/2024. He was suspended by passing the order dated 10/4/2024 with effect from the date of suspension. Lordship, memorandum of charges was issued on 26/4/2024. That was well within 3 months period, Lordship.
26 or 24?
26.
26/4/2024.
26th of April.
So that is well within, Lordship, he filed one representation on 29/4/2024. He submitted his reply, that is not important. And the review was, first review was on 6/12/2024. Slight delay, Lordship. 6/12/2024. It was not along with the memorandum of charges that was issued on 26/4/2024.
Separately.
Yeah. It was memorandum of charges was on 26/4/2024 and review was on 6/12/2024, first review.
After delay of?
It is around
How
4
many days? Months?
around
They ought to have done it by October. They ought to have done it by 25th of October.
If you calculate taking the 6 months.
Yes.
Okay. That means 8 months.
about 8 months, Lordship.
About 8 months.
Not about, Lordship, it is 7 months, few days, Lordship. Now, Lordship, if Lordship comes to the prayer of the petition, Lordship, Lordship, it was his submission in the petition that till date, no review has been done So his suspension order should be set aside and he should be reinstated.
The date of filing, kindly see the date of filing.
It's okay.
That was his prayer. And subsequently, it was placed before the court that no,
We was patiently hearing you.
Yes,
You
I'm
give
sorry.
the same courtesy.
I'm sorry.
Extend the same courtesy.
Yes, yes.
and
Yes.
during the pendency of the case, Lordship, it was placed before the court by filing an affidavit that no, subsequently his suspension was reviewed on 6/12/2024 and it was extended.
Hmm.
Now, Lordship, this extension order, that is 6/12/2024, firstly, Lordship, this is not under silence. Rightly or wrongly, Lordship, one order was there and that order has been placed before the court and that order still today has not been silenced. Now, Lordship, it comes to the legal position, Lordship. Lordship, under the Assam Services Discipline and Appeal Rules, the provision for suspension is Rule 6.
Hmm. Yeah.
Rule 6.
Yes.
Suspension, Lordship, it's not a long provision, Lordship. Suspension 6. This is part 3, suspension rule 6. Suspension 1. The appointing authority or any authority to which it is subordinate or
Just wait.
any other authority.
Rule.
6, Lordship.
No, what is the name of the rule?
Suspension, Lordship.
Uh-huh.
This is part 3.
Yes. The appointing authority, yes.
Yes. The appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension, A, where a disciplinary proceeding against him is contemplated or is pending, or B, where in the opinion of the authority aforesaid, he has engaged himself in activities prejudicial to the interest or the security of the state, or C, where a case against him in respect of any criminal offense is under investigation, inquiry, or trial. Lordship, so far as 6(1) is concerned, these are the 3 grounds on which, Lordship, the state government can place one employee under suspension. If Lordship comes to 2, provision 2, a government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended with effect from the date of such detention by an order of the appointing authority and shall remain under suspension. Lordship will kindly see this word, until further orders. So there are 2 provisions, Lordship. One is 6(1). 6(1) is in contemplation of departmental proceeding. And there is another provision which is a deemed provision. If the person concerned is under custody for more than 48 hours, he shall be considered as suspended by operation of law. And the law settled by the Supreme Court, Lordship, in this regard is that in case of deemed suspension, even a formal order is not required to be passed. The person concerned will get.
Okay, that's not issue. Issue is this, sub-rule 2. What you are trying to point out is sub-rule 2.
In the present case, Lordship, the petitioner.
Remain under suspense until further orders.
Until further order.
According to you, there is no fixed time limit.
Now, when this person will be reinstated until further order, it will be decided by the authority only. Lordship, my submission is not that. My submission is that so far as 6(1) is concerned, it is in contemplation of departmental proceeding.
No issue.
So far as 2 is concerned, it is not in contemplation of departmental proceeding. It is by operation of law. Then where is the requirement for the state authority to initiate a departmental proceeding? First, if it is not the obligation of the departmental authority to initiate a departmental procedure, Lordship, then where from the question comes of issuing a show cause notice within a period of 3 months? My submission. So far as 2 is concerned, I am not under any.
Therefore, if you are on the operation of the law, if a person, employee is suspended,
Yes, Lordship.
so there's no question of inquiry, you will not initiate.
Lordship, because we will wait till the completion of the criminal proceeding. Only thereafter we'll decide whether we'll initiate any departmental proceeding against him or not. Because Lordship, if Lordship comes to the first provision, 6(1)(c), where a case against him in respect of any criminal offense is under investigation, inquiry or trial. If a case is under investigation or trial, on that ground also we can keep him under suspension under 6(1). Lordship, my submission, this is Lordship, my submission, but we are, in this case, Lordship, we are not on this point. Lordship, if Lordship comes to the provision of 6(5), Lordship. 6(5).
Hmm.
6(5). An order of suspension made or deemed to have been made under this rule may at any time be revoked by the authority who is made or is deemed to have been made the order, or by any authority to which that authority is subordinate. So this is the prerogative of the government only to revoke the suspension order. I am not on that point also, Lordship. Now, if Lordship comes to the manual, Lordship, 2.1.8, before that, if Lordship comes to page 57 of the manual, Lordship. So this is a manual regarding Rule 6(1). Page 57, Lordship.
We are not concerned Rule 6(1).
Lordship, I am showing. He is asking for review. I am showing where is the review provision. Page 57, Lordship, Rule 6(1). 57. This is Rule 57. I mean, page 57, sorry, page 57. Page 57, Lordship, down below, Lordship, suspension by whom and when government servant may be suspended. This is, Lordship, Rule 6(1).
57.
Yes, down below. Rule 6. Rule 6 of the main rule. And these are the manuals relating to Rule 6(1).
57.
Yes. Page 57, Lord.
6 point.
Rule 6, down below, Lordship.
Page 45 only, this is.
Page 57, manual, Lordship.
Yes.
Ekon book no.
Departmental proceedings.
This book, Ekon book no. Ekon here.
2 point, what?
Lordship, chapter 2 of the manual, Lordship.
2 point?
This is 2.1.1.
2.1.1.
No, Lordship, first the rule is mentioned. Rule 6(1). Book document, book on modify this. Ekon book asil to. Book document kora kajisile. Ekon puroni problem. এখনো ম্যানুয়াল তো নাই এখনো ম্যানুয়ালি নাই suspension. Same group না এখন Chapter 2, Lordship, suspension.
That was, we are looking for it. You said 2.2.1.
2.1, but before 2.1.8, Lordship, kindly say Rule 6(1). Rule 6(1). So this manual pertains to Rule 6.1. Now, if Lordship comes to Rule 2.1.8, I mean Guideline 2.1.8.
Yes, he has read it.
Lordship, this Guideline 2.1.8 pertains to Rule 1. Am I clear, Lordship?
Hmm.
Now, Lordship, may kindly see what this guideline provides. The following principles and procedure with regard to suspension need strict compliance. 1. Suspension should be resorted to only when we are not concerned. 2. Charges and statement of allegations should be served within 3 months from the date of suspension, following which the government servant concerned should be reinstated. We have no objection, Lordship. This is Ajay Chaudhary, first part. Rule 3, Guideline 3. In cases where it is not reasonably practical to prepare the charges for service within 3 months. Are we concerned with this provision, Lordship? This is a provision when charges would not be prepared and submitted, served before 3 months. So this portion is not, we are not concerned with this portion. So far as Rule 2.1.8 is concerned, we are only concerned with Rule 2. That is, within 3 months, I have to issue the memorandum of charges. That we have done. So far as Rule 6.1 is concerned, there is no provision for review of the suspension in the rule as well as in the manual, Lordship is seen. Now, if Lordship comes little below, Lordship Rule 6.2, little 6.2, Lordship. Now, 6.2 starts from 2.2.1 to 2.2.7. 2.2.1 to 2.2.7. Nowhere in this guideline, Lordship, has there any mention.
It's prepared when?
Prior to Upendra's law, prior to Ajay Chaudhary, Lordship.
Then you have issued an office memorandum.
Yes, I'm coming to that also, Lordship.
You
I'm
come to
coming
that.
I'm coming to that, Lordship. What I am submitting, Lordship, in the rule, there is no provision so far as 6.2 is concerned that I have to issue a show cause notice within a period of 3 months. That is one. Second,
Therefore, this office memorandum, you come
yes.
to this.
Second, there is no provision in the rule that I have to review the suspension order for extension. Even there is no provision for extension of reviewing the.
As per the guidelines.
Yes.
As per the guideline.
Then, Lordship, one judgment came, Lordship.
6465 of 2017. Right.
Yes, Lordship.
Let's not go into all these things.
Lordship may kindly say why that judgment, why that notification was issued? Why that
Let us interpret the notification.
Yes. Lordship, there is a guideline of 4th February 2020. In the first portion, Lordship will see at page 41 of the writ petition. The first line states, Honorable High Court in its order dated 30/11/17 in a series of writ petitions, the lead case being WPC 6465/2017, has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India, case to the effect that the disciplinary authorities are to strictly comply with the requirement to issue memorandum of charge sheet before the expiry of 3 months from the date of issuance of the order of suspension. Now, if Lordship comes to the judgment dated 30/11/2017, in the judgment.
What do you want to say? This is your own memorandum, sir.
Yes, Lordship. I have a purpose, Lordship. That is why I am showing it.
Then,
If Lordship comes to the last page, Lordship. Lordship, paragraph starts with the word in the aforesaid circumstances. In the aforesaid circumstances, this court deems it necessary that an order be issued directing the Chief Secretary to the Government of Assam to issue a notification indicating the law laid down in paragraph 21 of Ajay Chaudhury's case, and also directing the disciplinary authorities in all the departments to strictly comply with the requirement to issue a memorandum of search sheet before the expiry of 3 months from the date of issuance of order of suspension. The notification shall provide that it shall be mandatory for the disciplinary authority to issue memorandum of search sheet before the expiry of 3 months from the date of the suspension. The notification shall also provide that in the event the concerned authority fails to issue the memorandum of search sheet before the expiry of 3 months from the date of issuance of the order of suspension, appropriate disciplinary proceedings shall also be initiated against the concerned disciplinary authority itself. Upon issuance of such notification, it is also directed that the Chief Secretary shall conduct a periodical review every 3 months of the various suspension orders issued during the previous 3 months and verify as to whether the aforesaid requirement has been fulfilled by the concerned disciplinary authority or not. Upon such review, if it comes to the notice that the particular disciplinary authority has not followed the above requirement, appropriate action of disciplinary proceeding be taken against him. In the notification to be issued by the Chief Secretary, it shall be specifically stated that even after issuance of memorandum of charges, the concerned disciplinary authority shall undertake a review as regards the desirability to further continue with the suspension order, and in the event such exercise of review is not taken, the same procedure as regard the non-issuance of memorandum of sources shall also follow. The notification shall accordingly also provide that the periodical review shall be done every 6 months. The aforesaid review, this is the review by the Chief Secretary, this is another review, Lordship. Now, Lordship, one thing Lordship has noticed in the rule as well as in the manual, that there is no provision for review. So far as this order is concerned, there is no direction for review within a certain period of time, a specified period of time.
6 months.
Lordship?
6 months.
Yes. Subsequent, court did not direct.
Shall according also provide that the periodical review shall be done every 6 months.
Periodical review by the Chief Secretary of the authorities, not of the Lordship. May kindly read that again, Lordship.
I've read it.
Lordship, 2 periodical reviews are there. Lordship,
In that case, you are saying that this is not in accordance, memorandum is not in accordance with this.
I'm not saying,
direction?
this is a memorandum of the state government.
That's
I
what
am
I'm
saying this memorandum, what
Hmm.
I am saying, neither this memorandum is contrary to the rule or the guideline, neither that memorandum is contrary to this direction passed by the Honorable Court. In fact, this memorandum has been issued with the backing of a judicial order, Lordship.
Then
Like if, Lordship, that period is not mentioned here also.
6 months.
6 months, Lordship, may kindly say again.
After issuance of memorandum of charge, the senior most shall undertakes a review within 6 months as regards the desirability to further continue with the suspension order.
Which line your Lordship is reading?
This is first, second, third, fourth
Para-
para,
Paragraph 16.
page 41. Read petition, para 41. Page
No,
41.
I am in the judgment, Lordship.
Judgment is clearly
No,
provided.
what I am submitting, Lordship, in the
What you are trying to say, this 6 months period is for the Chief Secretary, whether there is a review undertaken by the authorities, that is what you are trying to
Chief
say.
Secretary, that period of 6
That is
months.
first periodical review by the Chief Secretary to the concerned department authorities
Of
is
the
one thing.
departments.
Then last one you read this shall provide.
I'm reading again, Lordship.
The
In the
notification
notifica-
shall accordingly also provide that the periodical review shall be done every 6 months.
By the Chief Secretary of the authority. Lordship, may I read that line again.
It will be very.
In the notification to be issued by the Chief Secretary,
It
it
shall
will also be specifically stated
even after
that
issuance
even
of
af-
memorandum charge.
search it, the concerned disciplinary authority shall undertake a review as regard the desirability of further continue with the suspension order, and in the event such exercise of review is not taken, the same procedure is as regard the non-issuance of memorandum of charges will follow. The notification shall accordingly also provide that periodical review shall be done every 6 months.
Yes.
Now, this periodical review, Lordship will find a reference in the above paragraph. Above paragraph. That is a periodical review by the Chief Secretary of the authorities, not of the suspension order.
That is your submission.
No, Lordship, I am showing the periodical review above, Lordship, in the above paragraph.
It's okay, sir. I've understood your
No, this
submission.
is important, Lordship. Look, if Lordship, I am reading paragraph 15, last paragraph, Lordship. Upon is issuance of such notification, it is also directed that the Chief Secretary shall conduct a periodical review. Periodical reference as if in the paragraph 16 has a reference in
See,
paragraph
there are
15.
two parts. As in Ajay Chaudhary, in this direction, one is for the Chief Secretary to review against the authorities.
Yes. That is periodical review.
No,
Periodical
yes, that
review.
also a periodical review. This also a period. There are two parts. One is by the Chief Secretary to the authority concerned, who whether there is a review or whether the charge sheet has been filed within 3 months,
Lordship may
or
definitely
whether
take
there is
view dot. But my
action initiated by the authorities. That is one part. Other part is, that is for Chief Secretary. Other part is, so far as after the issuance of the memorandum, within 3 months, it has to be reviewed by the authority within 6 months. So, with regard to the desirability of extension of the
Lordship,
suspension period.
Yes. That may be a view, Lordship. But so far as my understanding is concerned,
That's why.
my understanding is
According to
concerned,
you, it is
this-
not the incumbent, as per the, either as per the office memorandum or the direction of this court, that no periodical review by the disciplinary authority
in the guideline,
is
Lordship,
required within 6 months. It is only for the Chief Secretary.
Lordship,
review.
yes.
That
It
is
is
what you are
only for the Chief Secretary to take periodical review in every 6 months of the departmental authorities, not of the suspension order by the disciplinary authority.
Then
So that is why in the guideline, Lordship, there is no mention about periodical review.
that will be it will be contrary to the, judgment of the Ajay Chaudhary.
Lordship, Ajay Chaudhary, I am coming, Lordship. Ajay Chaudhary, I am coming, Lordship.
No, it's
Ajay
over.
Chaudhary, I am coming to
No,
Ajay.
it's over. I've understood what you have
No,
submitted.
Lordship, I
You
have,
are saying that neither the court has directed nor the office memorandum provides for periodical review
Yes.
by the authority within 6 months.
Lordship,
It is
my,
only the Chief Secretary who will have a periodical review on the officers.
Lordship. Lordship, one review was by the, Lordship, as per this direction, the authority was to take a decision as regard desirability of extension of the suspension order. But for that, in this judgment, no time frame was fixed.
Kindly see page 41, para 4. After issuance of the memorandum of charge sheet, the senior most secretaries shall undertake a review. You read your own memorandum.
Yes, I am coming to that, Lordship.
Please come, no.
Lordship, I am coming to that.
According to you,
Till-
it doesn't
till-
provide
Lordship,
for any
till-
periodical review. It is
Yes.
6 months by the disciplinary authority.
Not by the.
It is only by the Chief Secretary. That
Yes.
is what, that's, I've understood.
Lordship, I am coming in
Come
a
to now
consequence.
here.
Lordship, what I am trying to show,
Ah.
in the rule, there is no provision for.
I heard you.
In the judgment, there is no provision
I have
for
heard you, I
period,
understood.
period, Lordship.
Understood.
In the guideline, Lordship,
Yes.
in the guideline,
There is no requirement of periodical review.
in the guideline, in the middle portion, Lordship, paragraph 4, after issuance of memorandum of charges, charge sheet, the senior most secretary shall undertake a review. Who will take the review, Lordship? Senior most secretary, not by the Chief Secretary.
Ah,
So that periodical review by the Chief Secretary, not of the suspension order.
ah.
Chief Secretary will take review of the departmental authorities.
That's why he is not relying. You may be correct the judgment.
Yes.
It's relying
No,
on
no,
your
I am
office
showing that
member
I am
data.
correct, Lordship. I am
Yes.
trying to show myself as correct.
Yes.
Like, Paragraph 4. After issuance of memorandum of charges charge sheet, the senior most secretary shall undertake a review within 6 months as regard the desirability of further continue with the suspension order. One, if Lordship comes to the next paragraph. Senior most secretaries will be held responsible. It is there in the judgment. Responsible for in cases of suspension if in their respective departments are not dealt with and reviewed accordingly. So there-
According to you, if it is not followed, it is to be, only the disciplinary action will be initiated against the authority.
that is the
And
consequence.
then this review, the suspension, whether it's illegal, allowed to be illegal or not, it doesn't, there's no
I am
reason.
not saying that. I am saying there is a provision for review of the suspension order within a period of 6 months.
Yes.
But non-compliance of that provision has a specific consequence, and that consequence is not of
The
reinstatement of the petitioner.
Reinstatement, that's what I'm saying. That is what you have said.
That is my submission, Lordship.
Yes, I've understood.
Delays may be there. There is a provision. I cannot dispute. But the non-compliance of that provision has a specific
That is the
consequence.
crux of your submission. You could have come to that immediately.
No, Lordship,
Is
what
that
I am
it?
submitting, Lordship, this is the only provision
That is
where
why,
a time
no,
frame for
I'm just saying, just listen to me. You are saying that there is a time limit for review. In case if it is violated, if it is not reviewed within, if it is not within 6 months, say, as per the memorandum, consequences will be against
action
the
senior
authority
most secretary.
secretary.
The consequence is not reinstatement of the
Reinstatement,
petitioner.
that's all.
Lordship,
That is
why
what-
I am showing this, Lordship? This provision of reviewing the suspension within a period of 6 months, first time incorporated in this notification only. Prior to that, Lordship, so far as the rules followed by the state government, there is no provision, absolutely no provision either for reviewing the suspension order or for extending the suspension order or extending that suspension order within a
So
specific
the
period of time.
employee will, they should be allowed to suffer.
I'm not saying that, Lordship. If it is not there, Ajay Chaudhary is not. Now, if Lordship comes to paragraph 21 of Ajay Chaudhary, in your Lordship's case, it is paragraph 14. Paragraph 21, Lordship.
Yes.
In in that copy, Lordship, it is paragraph 14.
14 years.
We therefore,
We have read it so many
Lordship
times.
will again read this, Lordship.
Today.
Lordship, because on this point,
You read it. I have read it so many
Lordship,
times.
on this point, Lordship, several judgment has passed, but Lordship will find various kind of judgments. In some cases, it is on the same day. In some cases, it is 3 months, and in some cases, there is 6 months. So there is no consistency so far as judgments passed by the,
So in the
Learned-
present case, it's more than 6 months.
yes, no, Lordship, what I'm submitting from 21.
Ah.
Lordship, they are saying that on the same date, on 3 months, what is my understanding? We therefore direct that the currency of the suspension order should not extend beyond 3 months if within this period, the memorandum of charges charge sheet is not served upon the delinquent officer employee.
Hmm.
That is one part, one semicolon is there. That is first part. Second part, first part is if no charge sheet has been issued within a period of 3 months, then the consequence will be default reinstatement. Second part, if the memorandum of charges charge sheet is served, a reasoned order must be passed for extension of the suspension. Where is the time specification, Lordship? So
Hmm.
far as issuance of a reasoned order is concerned, where is the time specification? It is a judgment, Lordship. We cannot put words If it is not there, it is not there. We cannot interpret even,
Yes, read.
if my understanding is correct.
Hmm.
If it is not there, not there. We cannot say that you have to issue the reason order on the date of submission of the show cause notice itself. It is not stated that you have to serve within, pass the reason order within 3 months, within 15 days, within 6 months. It is not there.
Yes. Suppose if it is, if you don't pass, even after 2 years, for example, in hypothetically, thereafter you give a reason order, will it be allowed?
So far as the guideline is
Suppose you
concerned,
have submitted the charge sheet
Lord.
within time, 3 months, no issue,
Lordship.
and you allowed to remain the delinquent or the employee under suspension without any review and all, that the Supreme Court or the law doesn't provide that it should be
Yes,
within
Lordship. That
6
is-
months.
that is-
Therefore,
That is
suppose if it is allowed to continue for years, say
suspect-
after 2 years, 1 year,
continuation of suspension for years if there is a criminal case is pending and if the charges are grave enough, then it is justified by the Supreme Court in constitutional benches, Lordship, for continuation. of
this
that
is
suspension.
continuation.
Yes.
Whether a review is not required in that matter also.
Lordship, that requirement of a review is not as per the provisions of a rule of the state, Lordship, and that rule was never considered by the Ajay Kumar Chaudhary in the Supreme Court. Our rule has not been considered. It was in consideration of the CCS rule. In the CCS rule, Lordship, there is a specific provision of issuing show cause within a period of 3 months and passing a reason order within a period of 3 months. That was what interpreted in the judgment of Ajay Kumar Chaudhary as well as in the judgment of Deepak Mali. Deepak Mali was in respect of CCS rule, not in respect of the state rules. And that there is a difference between the state rule and the central rule. There is a provision in the CCS rule that you have to review the suspension order within a period of 3 months. And if it is not done, then the person will get default reinstatement. Where is that provision in the state rule, Lordship?
Where it is?
In the CCS rule, Lordship, if Deepak Mali's judgment is placed, Lordship.
Deepak Mali?
Yes, one judgment passed by the Supreme Court in Deepak Mali.
Diganta,
Yes,
Diganta.
Lordship. So Deepak Mali, Lordship, it was CCS rules.
Diganta Kalita.
Not Diganta Kalita, Lordship, Deepak Mali. Lordship, there is a provision under the
Where
CCS
it
rule
is?
that is 10.6 and 10.7.
Where-
Therein, Lordship, it has been specifically stated that if no review has been done within a period of 3 months, then the person will be reinstated. That is a provision of the law. And that is what simply reiterated by the Supreme Court.
In Ajay Kumar.
In Ajay Kumar Chaudhary also, Lordship, it was CCS rule. And on these 2 points only, Lordship.
You read para 8, 9
Of Lordship.
with Ajay Kumar.
That is a different issue, Lord. We are basically on the point of continuation of the suspension. Good, good.
So you are trying to distinguish.
Lordship.
According to you, these are distinguishable.
In fact, it has been distinguished. Lordship, I am placing one judgment placed by the Madras High Court, Lordship. It's a full bench judgment. If Lordship comes to paragraph 34. Three judges, Lordship, full bench, paragraph 34, Lordship. And the paginations are there in the below portion, Lordship. Paragraph, page 44. Paragraph 34, your Lordship, allow me to read, Lordship. For the foregoing reasons, the reference is answered by holding that the judgment of the apex court in the case of Ajay Kumar Chaudhary Supra does not lay down absolute proposition of law that an order of suspension cannot be continued beyond the period of 3 months if the memorandum of charges search sheet has not been served within 3 months. We are not concerned. Second portion, or if memorandum of charges search sheet is served without reason order of extension. Lordship, in the similar line, Lordship, I can place.
No,
at
no,
least-
absolute does not lay down absolute proposition of law
Yes.
that an order of suspension cannot be continued beyond a period of 3 months if the memorandum of charges, a charge sheet has not been served within 3 months, or if the memorandum charges is without reason order of extension.
In both situations. Even if search sheet has not been issued within 3 months, it can go beyond 3 months. And even if reason order is not punched within a specific period, it can go beyond. So that is the law, Lordship.
This is not the law. This is Madras High Court.
It's a full bench, Lordship. And Lordship will surprise. I can place at least 7 judgments passed by different high courts, all division benches, holding the same proposition of law. Lordship may kindly see the justification at paragraph 22.
Yes, you read it again. It may be correct.
34.
Yeah, no, yes, 34 it says that the Ajay Chaudhary case does not lay down the absolute proposition that even if the memorandum of charges are not filed within 3 months, the cannot be the suspension cannot be continued.
So if
Now,
I am correct,
and if even if the memorandum of charges are filed
not fine.
with reason order of extension,
Yes.
with reason orders, without reason orders of extension. It's correct. We agree. It's not the case by the Ajay Chaudhary.
Yes, that is what I'm submitting. So
Here is,
by citing
here
Ajay
is a
Chaudhary-
case, they are not saying that, when there is in the Diganta Kalita, what is this?
Diganta Kolda, yes.
Diganta Kalita, it has to be accompanied by
The first thing, so
reason
far-
order,
so far-
reason order.
Yeah, Diganta Kolda says on the date of issuance of the so cause,
Yes.
it should accompany with the
But
reason.
Supreme Court doesn't say so, but then when you have provided a
is-
review provision within 6 months.
No, I'm coming to that, Lordship. So far as the,
No, we
now
can-
what is the basic claim of the petitioner, Lordship? By following Ajay Chaudhary, you have to review my suspension within a period of 3 months.
6
and-
months.
Lordship, 6 months is guideline. Then if it is 6 months, Lordship, why you are placing Diganta Kolda? Why you are placing Diganta Kolda? Now, if he is saying,
Diganta Kolisa also
Diganta Kolisa 3
relied
months.
this suspension order,
3 months.
the office memorandum.
3 months, no, office memorandum has not been considered, though it was placed. That is my case, Lordship, and that is why against this judgment, one appeal is pending.
It's okay, if it is pending.
So that notification was placed, but that notification was not considered, and the court hold,
I have understood you are supporting this office memorandum,
yes,
but as the office memorandum says that it has to be reviewed within 6 months, the consequences of reviewing of the suspension order,
should not be reinstatement of the petition.
it's not there. That's
It should be taking action against the person,
So,
officer concerned.
the suspended employee will keep suffering.
At some stage, Lordship will definitely decide, and that provision is 6.5, I have shown your Lordship. Lordship will, authority will decide when the suspension order is going to be. Lordship, on one judgment I placed, Lordship, I am not placing other judgment on the applicability of Ajay Kumar Chaudhary, so far as issuance of SOCON, I am not placing, but there are at least 7 judgments of different high courts, all division benches I can place. I am not placing.
Do we have our own high court judgment?
Lordship, our high court, Lordship, will find one judgment in Rekibuddin.
Huh?
Rekibuddin Ahmed. So that was the first judgment division bench was considering so far as the Ajay Kumar Chaudhary is concerned.
Huh.
In that judgment, Lordship, it was a referred WPC, Lordship.
Huh.
In that issue, in that petition, Lordship, issue was whether a suspension under Rule 6.2 would also be governed by the Ajay Chaudhary judgment. That was the question referred. And court says yes, Ajay Kumar Chaudhary will also apply in case of Rule 6.2, suspension under Rule 2.
Operation of law.
That is judgment. At that point, I'm not disputing. As there is a division bench judgment, Lordship, at this stage, I have no question of disputing what the division bench has decided.
Huh.
I'm not going to that extent. Lordship, I am placing some other judgment, Lordship, on this point. This point means on delayed issuance of so cause notice and delayed passing of reason order or reviewing the suspension order. What is the view taken by our High Court in various judgments, Lordship? Few judgments I am placing, Lordship.
Not few judgment, give one which supports your case.
In fact, Lordship, all these cases supports my case, Lord.
Then one on the point, there will be 1 point only.
Lordship, one important judgment I am placing, Lordship, that is 5966/2024. 966/2024.
Yes.
Ajay Rathipa print out the syllabus.
Note it down. I asked her to note down the judgment.
Ekan to judgment. Produce for them. Lordship, in this case, I am referring to paragraph 4, 5, 16, 17, and 21.
Just write it down.
Paragraph 4, 5, 16, 17, and 21.
This on what point?
In this case, also according to court, Lordship, although search sheet was issued within time, the suspension was reviewed beyond time, Lordship. And ultimately court directed
Beyond when?
beyond, 3 months period.
What about on 6 months?
It was within 6 months, factually different.
Where on 6 months? In view the.
6 months was not considered because the notification was not
Stated
clear.
unless and reviewed within 90 days extended by furnishing proper reasons, the same would lapse your operation of law and the same cannot be given a fresh lease of land by carrying out a review after the expiry. It is apparent from mention recorded on each occasion up to the court review. The review of the suspended is carried out after the period. Although the successive orders of extensions as well given respective of from a date on the meeting pattern, yet such orders are undertaken. In the delay in issuing the orders to find extension of service. There was delay in issuing the orders notifying the extension of suspension order which further imposed.
16, 17, 18. But in this case, the honorable court held, although there is a delay in issuing in reviewing the suspension order, that is beyond 90 days, according to the court, in this case, the period is 90 days. Court said, as the proceeding in the departmental proceeding was almost over, court preferred not to interfere with the suspension order, and court directed to complete the departmental proceeding within a specified period of time, Lordship.
On its peculiar facts.
Lordship, in the present case also,
But in any case, it was held that it was beyond the period of 90 days.
yes,
Which could not.
but court preferred not to interfere with the suspension
Saying
order.
that in view of the peculiar facts of this case,
Lordship, similar is
relying on the Supreme Court, which was in a peculiar facts, saying that by observing that the employee himself was not hesitating to participate in the departmental
that is
proceeding.
one way.
So that is,
No,
but
Dombi-
ultimately it
no,
held that
no,
the beyond,
no, Lordship,
without reason
no,
in this case.
No, Lordship, in this case,
Sir.
Kalyan Dambiveli is a different case, Lordship. In this case, Lordship, departmental proceeding was almost over or the inquiry report has.
That's what I'm saying, that's why I'm
Lordship,
saying.
in
On
this
specific
case
facts
also.
and peculiar facts it was rendered, but
Similar is
the
the, similar,
observation of the court is that you could not have reviewed it beyond the period of 90 days in this case, which you have relied. And it has to be supported with the reason orders, continuation or extension. That is what the law it has been. But
yeah.
non-interference and not, no direction to, not directing to,
reinstate the
reinstate.
petitioner,
It's only on its
as the
peculiar facts.
departmental proceeding was almost at the Again, Lordship, I mean, in that case, Lordship, most probably the search, the inquiry report was.
So what
already
about
sent.
your case?
In this case, Lordship, yesterday evening, I talked to the concerned IO, Lordship, and he said within 45 days, we are going to complete this proceeding.
45 days?
Yes. So Lordship, at best, Lordship will, the authority will take 60 days time, Lordship, at best. So they are saying 45 days will be sufficient. At best, they will take 60 days time.
Okay, we'll see, we'll examine. You have
Lots
raise a interesting point. Whether this court will be convinced or not, I'll examine it. But you have raised trying to,
No,
raise a very interesting.
I admit.
I find it interesting.
Yes.
You try to distinguish the Supreme Court
Lordship,
judgment.
I admit that it was beyond 6 months time.
Ah.
But at the same time, Lordship, first,
But your interpretation.
consequences should different. Lordship, on
Your
that
your
one-
interpretation of your own office memoranda,
yes.
I'm
Office memorandum,
little
it can be-
doubtful.
Lordship, that is why I was placing the rule. That is why I was placing the judgment passed by Honorable Justice A.M. Bujar Bora in person to which Lordship this notification.
Yes, that I have understood.
In
That's
neither,
why I find it interesting.
neither in the rule nor in that judgment, one period has been specified,
Whether this court is convinced or not, there is another.
nor in the case of the
Ah,
Ajay Kumar.
But
Sodha.
the way you have projected the case, I find it interesting. Yeah, we try to interpret the judgment of the court and your own office memorandum. That's all.
Lordship, one judgment I am placing so far as the consequence is concerned, Lordship. Paragraph 133.
For one matter, why the tree has to be changed, keep on changing.
133.
Sir, this is the difficulty. We are just stuck to one matter since morning.
Lordship, this is very important matter for us, Lord. Lordship, this is not the one case, Lordship. And
But
almost all
ultimately,
the
that will be
cases-
decided by the division bench. You have taken to appeal against the
So,
Diganta.
but Diganta Golda is Lordship, Diganta Golda is clearly distinguishable because there the notification of 2020 was not under considered, Lordship.
Why not Supreme Court? Why all other high courts?
This is Supreme Court, Lordship.
Huh?
This is Supreme Court, Lordship. No, Lordship, this is High Court of Bombay.
Ah.
No, no, he can more than one of them. Global aviation, no, out of the Bombay High Court ने court out दिया है Para 133 भी report लिखा है. What's paragraph 133, Lordship?
I think, sir, it's enough.
No, that, so far as that consequence is concerned, Lordship, whether it is directory or
Para-
mandatory, Lordship. Para 133,
133.
page 38. Paginations are down below.
There is no pagination also.
Down below, Lordship,
No pagination.
38.
Para 133.
Yes, Lord.
Insofar as the submission.
Insofar as the submission of the learned counsel for the response number, that if section 34.5 is considered as directory, the entire purpose of the amendment would be rendered. Otious is concerned, in my view, there is no merit in the submission made by the learned counsel for the respondent. Since there is no consequence provided in the said provision, in case of non-compliance thereof, the said provision cannot be considered as mandatory. That is my point, Lordship. In fact, this point has been decided by the Supreme Court, Lordship. Unfortunately, the Mumbai High Court judgment came.
Huh?
This point has already been decided by the Supreme Court in various cases, Lordship.
Where?
Today, Lordship, I got this case only, Lordship.
Huh?
Today, I found this case only. Lordship, that point, Lordship, in paragraph 4 of the notification, although there is a consequence specified, but that is not the consequence of reinstatement of the petition. And that is the legal position, Lordship. So basically, this is my case, Lordship. There are some other judgments are also there. In similar cases, Lordship, in one case, no show cause was issued within 3 months. Court directed the authority to issue show cause. In another case, Lordship, no review was done within 3 months. Court directed within 7 days you review the suspension order. In one case, Lordship, court say, as you have already issued the show cause, there is no necessity of passing a reason order. Lastly, Lordship, I am placing just one paragraph of paragraph 22 of the Ajay Kumar Chaudhary, Lordship.
Where is that judgment? Which says that,
I'm furnishing copies, Lord.
no, just don't punish, just give me the particular, not all the judgment.
Yes, Lord. Exactly.
You have said that since the memorandum of charges have been filed, submitted, or
Yes.
so cause notice has been submitted, given, no reason order is required
Yes.
for extension of the suspension.
Lordship, one case is WPC 338
Just give me.
2022. It is there? Ramadan. Go take it, yeah. In
Don't
fact-
give all the judgment, one only.
No, issues are different, Lordship.
Almost we have taken.
Lordship, I have marked the
half of
paragraph.
day and
I
then
have
you are
marked the
just
paragraph.
submitting all
Lordship.
those.
I have marked the paragraph, Lordship. In 338, it is Lordship 24567.
Para?
Lordship, I am relying 24567. Lordship, if Lordship comes to the last page, Lordship,
There is no paragraph also.
paragraph not marked. If Lordship comes to the last page,
This is the.
in view of above, Lordship, I dispose of this writ petition at the stage of motion, hearing directing the respondent number 4 to review the order of suspension, pass appropriate orders therein in the light of the observations in paragraph 7, so and so, within 7 days. But, so review was not done, court said now review you.
Your
and-
case review has been done.
Yes, subsequently, here the only delay. But here, Lordship, even after elapse of
Just
that,
relevant, take it back. Other one, after the passing of charge sheet, the submission of charge sheet, no reason order is required for
Yes, this
extension
is-
of the suspension.
this
That-
is
that I
Lordship
want.
WPC 7015
Just give me.
2023.
Just give me.
7015 2023,
Let us not consider which is not relevant.
paragraph 9, Lordship.
Ah.
On a reading of the paragraph 22 of the case of Ajay Kumar Chaudhary, it appears that as the so cause notice has been issued to the petitioner, there is no requirement of passing a reason order for his continued suspension, and the extension order of suspension would suffice.
There is no required passing of a reason order for his continued suspension,
Yes.
and the
Lordship,
extension
there is-
order of suspension would suffice.
Lordship, there is another case, Lordship. This is IA civil number 3702 2023. Lordship, in this case, Lordship, so cause was there. Review was not there. Second paragraph, Lordship. However, the order of suspension of the applicant writ petitioner has not been reviewed till today. এটা কপি দি থোৱা আছে, সিহঁতে দি থৈছিলে। দিলে এইটো? Lordship, in the IA civil, Lordship, one IA civil 3702-2023. In the second paragraph, Lordship may kindly see. In the second paragraph, fourth line. Second paragraph, fourth line. However, the order of suspension of the applicant writ petitioner has not been reviewed till today. If Lordship comes to the ultimate paragraph, Lordship, last page. Last paragraph, Lordship, HS. HS has agreed to by learned counsel for both the side, this IA is being disposed of by providing that the OP numbers 1 to 5 would consider the representation that is so and so submitted by the applicant and pass a reason order therein within 2 weeks from the date of receipt of the certified copy of the order. So even after elapse of that specified period, Lordship,
That is agreed by the
Court
parties
was-
only.
I mean,
Yes, sir, is
liberal enough to
is
gra-
agreed to by the land council both sides.
so
The
far as,
consent order
so my submission is so far as that period is concerned, court is not that rigid, Lordship. Just like in case of Diganta Golda, Lordship, in all these judgments, Lordship. Just 2 paragraph, very small paragraph, Lordship. One is Ajay Kumar Chaudhary.
How many judgments, sir?
2 judgments, Lordship, only.
How
One
many
la-
more judgments?
last paragraph of Ajay Kumar Chaudhary, Lordship. Last
Read it, read it.
Last paragraph, Lord, small paragraph. So far as the facts of the present case are concerned, the appellant has now been served with a search sheet, and therefore these directions may not be relevant to him any longer. I mean, the direction passed in paragraph 21. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondent will be subject to judicial review. So in this case also, Lordship, so cause was issued during the pendency of the case before the Supreme Court. That is after 4 years of initiation of departmental proceeding. But although the court directed review, I mean, so issue so cause within 30 days in case of others, so far as the petitioner himself, Lordship, never got the relief from the Supreme Court.
Obviously. that was-
And
the
one
facts-
judgment,
facts
Lordship,
are
Ajit Sunwal, that has been placed by my friend, Lordship. Ajit Sunwal, last paragraph, Lordship. Here the court interfered. So review was not done within 90 days. So the court preferred to interfere, but at the same time, court granted liberty to the authority that you suspend him now under Rule 6.1. Even if court is interfering, your suspension under 6.2, because of the reason that it was not reviewed within 90 days, I am giving you the liberty, you suspend him under Rule 6.1. I am assuring your Lordship, considering the graveness of the accusations, Lordship, allegations, authority will definitely suspend him even if this suspension is interfered in this matter.
No issue, it's up to you.
Obliged, Lordship.
My lord, very short reply. My lord, first thing as regarding my lord, the prayer. This writ petition was filed on 11/11/24 and the first review was in December 6/12. So I could not have, my lord, brought it on record. My lord, as regards, my lord, the other contention.
But they have filed a affidavit bringing on the facts.
Yes, they filed it. No. The writ petition was filed in the month of
Ah.
November, and the first review was in the month of December, subsequent to after issuance of.
That's what I'm saying, they have brought on record.
Yes, I'm not
You could have
disputing.
challenged it.
No, I have filed an additional affidavit challenging the same pilot. This is a writ petition. I've already filed pilot. There is prayer for taking it to be a part of the writ petition. There is an additional affidavit filed by me.
Challenging that.
Yes, madam.
In additional.
Yes, my lord. This is a writ
Where it
petition.
is?
Yes. The additional affidavit was filed on 10/3/2025. Lordship will come to running page number 45.
An
my lord.
affidavit of opposition filed by the, filed for, and on behalf of respondent number 2. Dipankar Umar Dada.
No, it's running page 45, my lord.
Huh?
Running page 45. It starts at 44. Page 45, para 2. The present additional affidavit is being filed to bring on record certain subsequent development in the matter that has taken place during the pendency of the instant petition in compliance with order of Senate. In the humble comprehension of the petitioner, the aforesaid developments are essential and relevant for the proper adjudication of the issues involved in the present list. As such, the petitioner respectfully pray that the statements made in this additional affidavit may be treated to be a part of the pleadings of the accompanying petition. And at para 4, I have brought on record that before they file their affidavit, I have filed this matter. Para 4, the review order is there. And this is an extraordinary jurisdiction where lordship can entertain any application by the law. And lordship will kindly note
You have annexed the first extension
Yes.
only.
yes, because at that point of time, only the first was there. I have filed it on 10th of this March. If your lordship is perusing the extension review order that is 612, lordship will file, there is no reason, my lord, for extension. It is to be a reasoned order. Where is the reason?
He said reason is not required.
Anyway, my
I am
lord,
also saying that this order is not under Sellen. Why we are going to the
yes,
reason?
this is under Sellen.
The order is not even under Sellen.
It is
It is
under
only
Sellen.
brought to the notice of the court.
There are two, my lord. This may be a treated as a part of the pleadings. Anyway, my lord. Next, my lord, there is a judgment of this Honorable Court Division Bench 2014-4 GLT, page 58, Akaddas Ali versus State of Assam, where the Honorable Division Bench has said, when this Honorable Court is in session of a matter, parallel adjudication is not permissible. When the writ petition was filed on 11/11/2024 and the notice was issued, my lord, without taking leave of this court, could they have reviewed this order, my lord, passed this review order, my lord? That is another aspect your lordship will look into. Parallel adjudication of by an administrative body when this Honorable Court is in a session of a matter is not permissible. 2014-4 GLT, page 58, my lord. Akaddas Ali versus State of Assam.
No, once when there is the power to review it, how can we stop them?
No, there is power to review, but that power has to be validly exercised. This Honorable Court is in session of a matter. That's why in Akaddas Ali, Honorable Division Bench say, you can't, the power is already there. It was not under challenge.
Okay.
But the power has to be validly exercised, my lord. And my lord, regarding their contention, that Diganta Kolda does not take into consideration that OM dated 4/2/2020 is absolutely misleading. At para 26, it has taken into consideration.
It was considered,
Ah,
but the
now-
proposition that 6 months time is there, that has been rejected. Court said at the time of issuance of so cause, alongside you have to issue the
Yes,
reason
yes.
order.
And my lord, as
Period
regards-
is 3 months.
let me give my
And
reply.
your lordship's judgments, lordship are also there. I have seen your lordship passing judgments holding that 6 months period as justified.
Now, lordship, as regards my lord, para 22 of Ajay Chaudhary, that was also considered being Diganta Kulta at para 39. I'm not reading because the lordship has already gone through everything. And there is, my learned friend referred to Ajit Sanwal. Lordship will kindly go to para 10 because Ajit Sanwal is a division bench judgment where it says, well, it is mandatory and partial. If the review or extension is done beyond, my lord, the prescribed period, it would be of no consequence. Para 10 to 12, my lord. 2023 6 GLT, page 115, my lord. And my lord, lastly, my lord, if there is something missing in the rules, a subsequent OM can always supplement it, my lord. That is the law. And my lord, under Article 141, in this case, my lord, and Article 141 will come to my rescue because Ajay Chaudhary, the ratio laid down in para 21 of Ajay Chaudhary is the law, and it will be covered by Article 141, and it will be applicable in each and every case of suspension, irrespective of the service rules, my lord. That is my.
No, he has distinguished that. He's not disputing that it's a bad law. It's not binding on him. What he said is, it doesn't say that on filing of charge sheet,
Yes.
The reason order and the review should be made within a specific period. That is not a law laid in Ajay Chaudhary, what he's saying.
But I'll humbly defer, my lord, Ajay Chaudhary, because it will have no meaning otherwise, my lord.
According to him, Ajay Chaudhary says that if the charge sheet is not filed within 3 months, it goes.
Yes, it will. That is the first part.
Only the second part doesn't say once it is filed. It doesn't require to, they give a reason for extension.
No, the reason, Lordship will kindly see para 21. The whole reason order is there, my lord. The whole reason is there. They have to pass a reason order.
No, what is submitting
Like
is
I
that.
said, Supreme Court used the word reason,
Yes,
but
yes.
Supreme Court has not made any specification
No.
within what time this reason order has to be filed.
Time limit may not be there. Reason has to be there. Para 21, here, my lord, para 14. May I read it, my lord? We therefore direct the currency of a suspension order should not extend beyond 3 months if within this period the memorandum.
Reason order must be
Ah,
passed for
yes.
extension.
Yeah.
No, it's okay. He has placed this other judgment of the coordinate bench where there is the reason order is not
I
required.
don't know the facts, my lord.
Once it is,
Lordship will kindly see the facts. It may be.
now, what he's saying is that maybe it has to be reason order, but there's no specific stipulation. There's no specific time limit.
Yes.
That is,
Once it is filed within 3 months.
that is one.
Ah.
Secondly, Lordship, when Lordship will consider whether in that order any reason is there or not. When that order is challenged, that is not under challenge.
Anyway, that is beyond, my lord, in my humble reply, my lord, the first review itself being beyond the prescribed time limit, it is known as in the eye of law.
Then he said it is not required.
But in my humble submission, it is required because they themselves.
Reason order may be there, but then there's no time limit.
Yes, to that, my lord, my reply is that it is their own OM. my lord. They cannot now hire from their OM, my lord. They have supplemented, my lord.
In
What-
case OM says, according to him, if it is not complied
Yes,
within 6 months,
yes,
the consequences will be there against the authority.
yes, against the authority.
There is no consequences of automatic or
That's why-
reinstatement,
That's why
reinstatement,
we are before your lordship.
reinstatement.
Yes, that's why we are before your lordship under Article 226. Lordship will examine and lordship will.
Are you getting?
Yes, I've got
What
it.
he said is, there is a 6-month period. In case if it is not done, right?
Right.
Consequences will be against the authority.
Yes, yes, but what
With
about?
regard to disciplinary proceedings or
Yes.
initiation action against that authority.
Exactly, now my lord.
It doesn't indicate that it will
That we
be
have to be reinstated. That
reinstated
I have understood.
as provided in the 2.1.8.
I have understood.
If
my
the
lord.
charges is not filed within 10 days, 3
3
months, it will be,
I've
employees will
understood.
be
Yeah.
reinstated.
Yes,
That is what he is trying to
yes,
say.
but what my humble submission is that lordship will see overall view. Lordship will kindly consider para 15 of the division bench judgment, 2000, my lord, 19.5 GLT, where it says prolonged suspension will take the color of a punishment, my lord.
He said he has taken it to division bench.
No.
So it
No,
is,
that Diganta Kolda is already.
he said
served.
Diganta Kalita has been wrongly decided.
Already joined, no appeal, let them show an order. Verbal submission will not do, let them show an order, my lord.
He has
Yes.
not said,
He has already joined. Once the order is complied with, where is the question of my
Not
lord?
joined, Lordship. Today morning also I have confirmed.
Hmm.
Because
Okay,
of the
okay.
pendency of the appeal, he has not been allowed to join.
Stay order, lordship, you produce a stay order then. Unless and until. the-
anyway, I will not go into, I'm just on a lighter note, I say,
Yes, so my lord, Article 141 will come to my rescue. The petitioner hearing is in the 19th month of
sir,
suspension.
don't go back to again. That's why for Article 141, we're just debating.
Yes, my lord, prolonged suspension order will, my lord, take the color of a punishment. Yes, exactly same has happened, my lord, and lordship will interfere with my lord. 19 month of suspension without, my lord,
We'll see.
yes.
Hmm.
Deeply obliged.
Obliged, Lord.
That's right.
My lord, I'm really grateful for giving us a patient hearing.
No, it's okay. What can we do? I don't normally hear, I mean, spend so much time. Otherwise, it will be very difficult to manage the cases.
Deeply obliged.
So and so. They put what learned counsel for the petitioner and also had Mr. P. Nayak. Learned additional AG,
Yes, yes.
additional advocate general, for all the response.
State response.
Let me see.
Lordship.
Let us see. Then in that case, judges said the hearing concludes, judgment reserved. Yes, next.
Item 6.
But this is a family pension matter, Mala. In fact, pleadings are completed. Both, he represent the private respondent, but the government also file affidavit. So for final disposal, your lordship kindly take up the matter today.
Today,
Mala. Since 2018, he is she is without any.
but you have
action,
filed a matter in 2024.
Mala.
Who is relying the judgment passed by the coordinate bench?
Malat, in fact, Malat, the issue involved is that Malat, the
Jyoti
family
Kalita.
pension, they preferred and that Malat, let me continue with my case. I'll clarify this, Malat. What happened in 2018? The husband of the petitioner has died. Malat, she was the surviving wife, second wife. First wife was died prior to her marriage with her husband. Malat, from the Malat earlier wedlock, the husband had 3 daughters. All the daughters were married now. Malat, she has also a mother-in-law. Malat, after death of her husband, Malat, the authority Malat sought for the information regarding Malat for that family pension matter Malat. Annexa Malat 1 Malat. There's a condolence message Malat, page 20 Malat. Then Malat. Annexa 2 is the death certificate of her husband, Mala. Is 23, Mala. Annexa 3, the letter dated 25/7/2018, issued by the commandant of that Mala organization under which Mala the husband of petitioner was working. It is a letter to the petitioner requesting for submission of the document and preparation of the compulsory pension proposal. So accordingly, Malot, Annexa 25, Malot, Annexa 4, Malot, page 25. The next of kin certificate was, my lord, the death certificate, next of kin certificate, my lord. 26 the relevant portion, my lord.
What about this, the case?
My case is that since 2018, the husband died.
No, no, regarding the judgment.
My lord, that judgment, my lord, they preferred, the private respondent, that means daughters and the mother-in-law preferred and succession, my lord, case before the district judge.
Yes.
So accordingly, I annexed the document, my lord.
District judge
Page,
has
my lord,
Ah,
page, my lord, annexus 6, my lord.
hmm.
The succession judgment was delivered by the district judge. Well, against which we preferred an instant appeal before this honorable court, and this honorable court, my lord, finally disposed of the matter with the direction that regarding pension, my lord, the succession, my lord, other, my lord, part, my lord, it can be, my lord, but regarding pension is as per the rule, my lord. It is, in the last part of the judgment, it clearly shows. Ulysses got the judgment before, my lord, that is there, my lord.
Page 37,
My lord.
appendix. Yes.
My lord, there is a judgment, copy of the judgment and furnished to the, my lord, in the record, most probably judgment is there. The last part of the judgment, page 21 onwards, my lord,
Hmm.
it is disposed of, my lord. The intestine case 4 of 2024 was disposed of. So regarding last page 24, most probably, article of dissolvement, so. However, liberty will be remain with the parties to oppose the appropriate authority or relieve and pension rule. Now, pension, then generally it is pension as per the rule. It is applicable as per the rule. In my my lord, in repetition, provision 143 of the rule is quoted, page 10, my lord. Then the rule is for your lords is a pension rule, my lord. I quote the pension rule relevant portion, my lord. Their rule one.
What about that case has been disposed of
Disposed of, my lord.
by the High Court?
By High Court.
Yes, that is, in this case, the interstate case,
Interstate case.
4 of 2024.
My lord.
Okay, so what happened?
Regarding that judgment, that the pension part is remain open, my lord. The
Yes.
authority can, once
Since
pension
family
is.
pension is not classified that under so and so, does not require a succession certificate for its display.
My lord.
The employment order.
That
In
is
respect of family is
as per rule, the pension,
directing to grant section in respect of family pension interest by how the liberty will evaluate the public purpose. Pension rules. Yes.
no. As
So
per
what is
that,
their stand?
their stand is that one of the debtor is unmarried, but we clarify in our reply that she along with the other, a person, he is already married. So none of them were entitled to the pension as per the pension rule. Pension rule 143(1) defines the.
Who is the private respondent?
I am appearing, your lordship.
You are a daughter.
Yours.
Daughter and
Unmarried.
mother-in-law, my lord.
Daughter
Unmarried.
and mother-in-law, your daughters and mother-in-law, your lord.
Two daughters and
Two daughters and mother-in-law.
mother-in-law. You are the,
Petitioner, my lord, second wife.
Second.
Who is surviving wife, my lord.
go for mediation.
But since the matter issue is very, my lord, simple and as per the, my lord, it can be disposed of by your losses. Otherwise, my lord, it will remain.
We are
there.
hearing for disposal only.
My lord, I am praying for disposal, my lord. Your losses take up the matter in the second half, my lord, at 2, my lord.
Continue at 2. But be little short, sir.
Definitely,
Small
it's
issue,
a
be
short
little,
matter.
don't hear in there,
It is a
unnecessary.
short matter, my lord.
Yes, sir.
Lordship, with slight indulgence.
I was about to ask you. I've seen you this morning also.
One item is there, I was, item 789, Lordship.
789.
So,
789.
yes, Lordship, that
Okay.
is a matter relating to recruitment in police.
Okay.
So I have some difficulty in the second half, Lordship, I am going away.
Okay.
Can it be taken up day after tomorrow? Lordship?
Yes, who is for the petition?
I think the opposite party is also here, the senior counsel MC.
Maybe your lordship.
Uh,
My lord, the last day also, my lord, my learned AG because we have to adjourn it, my lord.
Next week,
And
next week.
My lord,
We'll
what
take it
happened,
up next
my
week.
lord, tomorrow they are going to issue appointment letter as per newspaper and everything, my lord,
So-
which is challenged here.
You're seeking for depth.
The
Which is
thing is
challenged
that
here.
there are 202 petitioners, 200 petitioners posts are protected.
My lord,
There
entire
is already
process
an interim
process is
order.
challenged, my lord, and my lord, so my
No,
lord.
interim
very
order
urgent
is-
otherwise.
is-
Otherwise protected.
If you are protected, even if the.
Our Lord, you may hear them today. I'll give my reply day after tomorrow. If there is urgency, but I have new things to bring also on record.
Day after tomorrow,
Yes, Lord.
My
day
lord,
after tomorrow.
My lord, they are going to appoint yesterday. We have challenged the entire process, my lord. Yes,
We'll
interim
take-
protection is
we'll
there, my
take-
lord.
When there
They
is
are
a,
going to appoint tomorrow, my lord.
if you are protected by interim order.
And also in the interim order, it is said that any appointment made, that will be subject to
Subject
final
to-
outcome of this week. That order is also there.
Posts are to be,
Posts are vacant, posts are kept aside, number one. And second is that if any appointment is made, suppose tomorrow appointment is made,
Ah.
their appointment will be subject to final outcome of the writ. That order is also there.
we'll hear it tomorrow, day after, sorry.
My lord, as per the notification came out on 29/11, my lord. They have not kept 202 post vacant. my lord.
Whatever, we'll see. Huh?
And that is also being violated.
Mr. This I can learn it. Advocate General, while expressing difficulty to the press for listing of these matters on 4th. List of
If
although,
it is on next week, it will be more convenient. I will arrive around 1 o'clock that day.
then why not next week?
My lord, this is the, my lord,
Tuesday, hearing day, we'll take it up.
my lord, let it be on Thursday next, my lord. We are in some,
Thursday next,
yes, my lord. Today it is Tuesday, my lord, to Wednesday and Thursday, my lord.
Wednesday, Thursday? Next,
Thursday, my lord.
next week.
No, my lord, this week, my lord.
No, he said Thursday, then we'll try on Thursday.
I'll try to be here at 1 or 2 o'clock.
My lord, maybe fixed at 2, my lord. My learned friend is busy, my lord. Maybe
As
fixed
agreed
at 2
to
p.m.
by- No, although the Mr.
Ek Taludar, my lord.
Then that's okay. Ultimately, you have agreed.
No, my lord, I'm not agreeing till, but your lordship is inclined to grant.
No,
time.
although Mr. A.K. Talukdar,
Well,
that
put-
is counsel for the petitioner.
I have objection, my lord.
Vehemently objected for fixing the about adjournment of the matter, considering that the learned AG has some difficulty today. Better be listed on so and so, Thursday, day
Well,
after tomorrow.
My lord, at 2 p.m., my lord. That's so that learned, my lord.
Lordship,
education-
Lord-
Then why not we'll make it sure on next Tuesday,
My lord, my lord.
on hearing day.
My lord,
Let us do it on a hearing day, next Tuesday. If
Tuesday
it
will
is,
be nice.
if your, the submission is accepted, that they are going to issue the appointment order tomorrow, either day after tomorrow or next week, it's the same thing. We'll give you a fixed date.
my lord, maybe, my lord, it will be very convenient for my lord. My senior is also not there, my lord. So maybe at 2 p.m. Thursday, my lord. My learned friend will be available at 2 p.m. He's saying, my lord.
Tuesday.
I will
Tuesday.
be available, all
Let us not
lordship.
take a chance.
At 2
Tuesday,
p.m.
Tuesday,
My lord,
next
maybe
Tuesday.
First half, he will not be available, saying.
It's a matter of one week only, sir. We'll hear.
My lord, matter is deferred, my lord. This is going on, my lord.
He's there.
Lordship, if they want to start the hearing, let them start. But they will
So
get
it's
a surprise day after tomorrow.
Sir, it's very difficult.
Then if they want,
Learned
then the
friend-
surprise will be
my-
there and
my
it will
lord,
continue
Tuesday,
for
sir,
next 6 months.
Tuesday, Tuesday,
For next 6 months,
When
it
is
will
Tuesday?
continue.
9th.
Well, in fact, in item number 6, we are paying for an accommodation. Can it be on 16? That is also a Tuesday.
Why?
But some, he has also some other matters he requested me.
Okay, as agreed to by London Council for the parties, list this matter on 16.
16. Highly obliged, madam.
Deep to.
May I please your lordship? This case relating to for payment of minimum pay scale to the petitioner, last order lordship may be looked into. They received verbal instruction from the authority and directed to place the written instruction. My name has also been shown forwarded. PNRD Department Lordships. That's it.
Yes, PNRD.
And finance also, last time also appeared for Puja also.
Who is A.K. Ghosh? Appearing for S. Datta. Inform. What about your information?
My case is that my name several times forwarded, but due to technical.
No, they say the petition has been approved for payment of minimum scale of pay.
Yes,
You are seeking for minimum pay scale of
yes,
pay.
yes. I am
So
seeking.
what
for
is your
minimum pay.
information?
I have no information. Information will provide.
Have you asked for
My
asked the
client,
petition?
my client has yet to receive lordship, payment not been received, but their information.
Whether it has been approved or not?
I do not know. They will clarify lordship. The last told before this one court lordships.
Please inform.
My name forwarded.
2811. Order is
Yes.
of 2811.
After some time lordship.
Is all option.
Yes.
So item 12 or 13 first, because there the pleadings are already complete.
12 or 13?
13? 13 or 12 was,
13.
I am appearing in 13, item number 13, and affidavit have filed lordship. In 12, SS Roy has,
It's okay, same thing.
Same
yes, lordship,
Posts are not same.
Post
Posts are
same,
different.
Post same.
same.
What is the post?
Post is Constable GD Lordship,
Constable GD.
general duty, yes, Lordship. In different central armed police forces, Lordship. Here, all the petitioners have been rejected by the PST board on the ground that they have not met the requisite height of 165 centimeter. The petitioners are assailing a relaxation that is provided under clause 2D of the detailed medical guidelines, Lordship. Now, your Lordship, that guideline, your Lordship will find at page
Item?
item 13, Lordship.
This is 13. 6436. Sorry. Same recruitment process.
Same recruitment. process,
Same advertisement.
Same advertisement.
Same armed forces.
Armed forces,
Central.
right?
06, WPC 590.
Same recruitment process issued by the Staff Selection Commission in pursuance of the same advertisement, Lordship.
Okay.
At page 59, your Lordship will find the relevant portion of the
Revised uniform guidelines for recruitment, medical exams for recruitments. What is GO?
the gazetted officers, Lordship,
And NGO, non-gazetted.
non-gazetted officers in CAPF.
The understand that is so and so providing there with draft uniform guidelines for medical exams for recruitment.
Lordship, the relevant portion is at page
This cover
64.
letter.
64,
Ah.
D.
May
I read, Lordship?
64.
Page 64,
There's no page 64 again.
measurement of physical.
64. What is the page?
64, nahi different, page 2. 64 page number, not here, lordship.
Here also.
No, no. 59, 60.
No, the same is missing. also.
63 then, Lordship. Page 63.
There's no page 64.
Page
Page 64 is missing.
Page 63.
Missing. I'm sorry, missing. Yes.
Page 63, Lordship.
D.
Sorry, Lordship. Yes, D.
Measurement of physical standard height, weight,
Height,
and
weight,
chest
chest
is
is
the
responsibility
responsibility of
of the-
physical standard test for all categories, conditions, and male and female since non-measure may be assumed. What is PST?
PST is physical standard test.
Recruitment medical officer need not record to physical measure. Requiring medical officer will mention physical standard in the medical exam form as according with the PST board in the borderline cases of overweight. So consider error at the conclusion variation of 5 kg. We're not, kg were not, weight were not concerned.
Not concerned.
Are we concerned about
No, no,
weight?
we are concerned with height.
Height only, right?
So from,
Similarly, while measuring
Similarly,
height,
yes,
fraction of cm less than 0.1 will be ignored
Will
and
be ignored and
0.5 cm
will be rounded off to the next.
and more will be rounded up to the next higher cm. Standard height weight chart is attached. Yes. Then,
So Lordship, they were all the petitioners.
I made
I'll get close to
Okay.
the again.
So what is your measurement?
My
So
measurement
the
164.8,
measuring fraction of cm less than 0.5
my lord.
will be ignored and 0.5 cm and more
Yes, my lord.
will be rounded up.
Yes, my lord. So it,
If it is less than 5,
it will be
0.5, it will be ignored.
ignored.
If it is 0.5 and above,
Yes, my lord.
will be rounded off
Exactly. If my lord now,
to the
Paris-
next higher cm.
if my lord now Paris page 57, my lord. Sorry, 55, my lord. My lord, for candidates from Assam, it is 165 is the requirement. If my lord Paris page 55, annexure C,
165.
page 55, my lord.
Yes,
Yeah.
then.
So 165 is the criteria. My lord,
yeah.
we'll see the fourth column measurement. My one is 164.8. So according to their own OM, my lord, it has to be read as 165. Now
Because it is below 0.5.
it is above 0.5, my lord. It is 0.8, 164.8.
Okay. So above 5.
Yes, my lord. So if it is above 5, my lord, now in my case it is 0.8. So it has to
Okay.
be read as 165.
Below 0.5, it should be ignored.
Ignored.
That is what? That means?
That means, my
Ignored
lord,
means what?
it cannot be rounded off to the upper.
So that will not be, I mean,
That will be considered as 164 if it is below 0.5.
yes, yes.
If
If it is above 0.5,
it will be rounded up to, my lord, 165.
Yes.
Rounded off to 165.
then you are
Entitled.
somehow.
There, I mean, entitled, my lord.
Yes.
Yes, Lordship.
You are
yes,
forced, you need to have that height.
True, my lord.
Anyway,
But it is their own OM.
what if the physics,
Which I have cleared, my lord.
test and all?
I have cleared.
Okay.
I have cleared computer test. I have cleared physical test. This physical standard test, my lord, PSE.
What about the weight?
Everything I have.
Only the height.
Only the height.
Yes.
Yes,
Very
Lordship.
simple.
He was rejected on PST, Lordship.
What is
And
PST?
PST means physical standard test.
Yes.
And it was conducted by PST board, Lordship. And as per our notification, Lordship, it is clearly mentioned that after PST, he will go for DME, will medical examination. And it will be conducted by the DME board. That is different. And in our notice advertisement, page 31. Kindly come to page 31,
Yes.
para 12.62. Here it is, may I read, Lordship?
30?
31. 30, this is 37. 37.
Page 37.
Yes, Lordship. Of writ petition.
Yes.
12.6.2.
12.6.
The shortlisted candidates will be medically examined by medical board constituted by CAPS to assess their physical and medical fitness. The medical examination of the candidate will be conducted in the terms of uniform guideline for recruitment medical examination for GOs and NGOs. CAPS and Assam Rifles issued by memorandum so-and-so dated 31/5/21 and as amended from time to time by government. he was rejected on PST. PST was not conducted by DME, Lordship. Detail and this uniform guideline is followed on at the time of DME. And where he was found rejected on the after calculating BMI. Kindly again come to page 63 of uniform guideline para 2D. Lordship. According with
So you are also, this is the guideline, right?
yes, Lordship.
63. Ah,
This is uniform medical guideline. It is applicable at the time of medical examination, Lordship. And detailed medical examination. And the petitioner was rejected at the time of PST, physical standard test, not DME. And this guideline, this rule is applicable on at the time of DME. Here it is clearly mentioned at para D.
so therefore his rejection is not on
this.
on height.
No, he was rejected on height, but at the time of PST, physical standard test. And after, if he qualified physical standard test, then he will be go to for DME, detailed medical examination. At the time of DME, he will be his BMI will be calculated. Body mass for which height will be measured, and at that time 0.5 will be rounded up. It is it is in clearly mentioned.
Medical exam, medical boards and to assess their physical and medical fitness. The medical examination will be conducted in terms of uniform guideline. So, and as accessible at the following. I'm not getting you, madam.
If I may submit, my lord, they say relaxation is entitled only at the stage of medical examination, not at the stage of physical test examination. If that be so, my lord, if a person is rejected at the physical test examination on that ground, without rounding it off, my lord, nobody will go to the medical board, my lord. This OM becomes redundant, my lord.
He may go, Lordship. If he get 165, then he will go to the DME. At that time,
There's no one, if it is 165, there's no question of rejection.
Exactly, this relaxation becomes redundant, my lord.
no, Lordship, at the time of calculating BMI, body, his weight may be at body mass.
That's why I'm asking which one you have rejected, which ground?
PST.
Height. Height only.
PST, at the time of PST, he was rejected.
Height.
Yes, Lordship. As per notification, Lordship, our.
What notification?
Advertisement. He should be 165. At page 35, it is clearly mentioned that the petitioner must be required the height of 165.
No, that's why similarly while measuring height fraction, what is this then?
Then it will BMI will be body mass index.
Yes, when BMI will be taken, that time 0.5 will be rounded up.
Where is that provision?
That 2D, page 63. Here.
Measurement of physical standards, height, weight, and test is the response physical standard test board for all categories of candidates and medical officer will not be part of PST board both for male and female. Since presence of a female is required at the time of non-medical step may be associated with it. Recruiting medical officer need not record the physical measurement. Recruiting technical medical officer will mention physical standard in the medical examination form as recorded by PST board. In borderline cases of overweight, BMI should also be considered to arrive at what is BMI?
Body mass index.
Should also be considered to arrive at conclusion
is
and
divided by
variation of
height.
kg plus minimum. Yes. BMI is not at the time of?
At the time of medical examination.
Now,
PST.
BMI should also be considered to arrive at conclusion and variation of so and so from the so and so may be accept limit maximum limit may be accepted. Similarly, while measuring height fraction of, I don't think so.
If I may.
See, suppose if a person is rejected on physical, suppose is it a chances of sending them back, sending to the BMI?
Yes, Lordship.
I mean, what do you call it? DMI, DME.
PMI is lordship after one crosses the PST lordship. If he not selected in PST, his threshold rejected lordship. PST. Here he cannot claim that this point fraction will taken care of at the time of DME if required lordship for calculating body mass index. At that point of time, the point fraction will be taken into care of.
No, once you are rejected, what's the question of considering that
He has rejected
fraction?
lordship. He doesn't as per advertisement.
Yes, suppose
Lordship.
if a person is rejected,
Lordship.
suppose in the for 160,
Lordship.
and you have to ignore in the DME the
Yes,
6.
for calculating other indexes. Because we have to take as per lordship kindly see, thereafter we have to take body weight index. 0.5, that's why we are taking it, lordship. But at the, kindly see the advertisement, first advertisement lordship, what are the required
It's
first?
okay, it's 165,
165.
right?
Threshold rejected. And if he qualified this lordship, then it comes DME lordship. Where
What's the question of DME?
then only that fraction will come to. Then only this.
See, if you insist that it should be 165,
Lordship.
what's the question of considering the fraction?
For
There's no question of
calculate-
fraction.
For calculating other factors, lordship.
No, it's height, clearly height.
No, BMI.
BMI, body mass index is there, lordship. Measurement
That's
of,
why I'm then what is, that's why I'm asking, on what ground you have rejected?
he was not qualified as PST because he could not clear PST, lordship.
Not clear, on what ground?
His height,
Height, that's what I'm saying. For height only, you require this, it has to be, if it is 0.5, it has to be rounded.
Their own
Read that. See, if he is rejected on some other ground,
lordship.
obviously this will not come. Isn't it?
Yes.
If it is only for height, you'll have to see whether I'm able to convey you or not. Suppose if it is rejected, no, not since he has been rejected on height,
Lordship.
without calculating or giving the benefit of this fraction, calculating this thing. What do you call it? Rounding of this thing, fraction.
Yes, fraction.
Then when the question of he gets the kind of the benefits in the DME when he is not there already.
In borderline cases, Lordship.
This is the borderline 6.48.
To calculating BMI, body weight has to be divided by height.
Body mass index has to be with the height, lordship. To
Height.
get the, suppose lordship, here's the.
It's very technical. We don't know. How can you be like this?
Average weight, lordship.
According to this will be only applicable at the time of DME,
DME,
not PST.
Not
Yes.
PST.
That cannot be because once this height rounding off cannot be done at PST, right? How can you expect that there will be again?
Lordship, kindly see page 87 in education.
Oh.
87, the male average weight, body weight in kilogram for different age groups and heights.
87?
87.
affidavit.
Of our affidavit.
Affidavit opposition.
Yes.
Oh,
87.
7.
Hmm.
Because of this, lordship, and for calculating the body weight, lordship, age in years, we have to take this. For this,
Male average body weights in kilograms for different age groups and heights. Average body weight.
Yes, Lordship, BMI is there to calculate that BMI. If it is come, then the fraction will come. Suppose Lordship 165 to 166 average age weight, then only Lordship that point will come, Lordship. To manage this, Lordship. Kindly say if the height is 166, then age in years, 49.5 to 60 we have to consider. Then 23 to 27, 51.5 to 62.5.
Age in years.
Yes.
Then finally.
Finally, Lordship, if it is one, height will be, suppose say 165.5, then at that time we will take this 0.5, Lordship, to round up to get the minimum, Lordship.
It doesn't indicate also.
May I submit for 5 minutes, my lord? Well, they have successfully confused everybody, my lord. At least they are confused. Their own OM says that my height will be rounded off to 165. Now they say it is for the BMI, not for height. My lord will kindly peruse their own OM, my lord, that guideline. Which my lord finds at the guideline. Page 62 of my petition, my lord. Page 62, the guideline starts, my lord.
That's where.
2D, my lord. My lord, kindly see. BMI has nothing to do with the height, my lord. Measurement of physical standard, that is height, weight, and chest, is the responsibility of the physical standard test board. Nowhere it says, my lord, medical board. It is PST again, my lord.
Yes, PST.
PST board for all categories of candidates of GOs, SO, and ORs. Medical officers will not be part of PST board, both for male and female. Since presence of a female, this is not relevant, my lord. My lord will see 6th line from the bottom in the right hand side, my lord. In borderline cases, the sentence starting with the word in borderline cases, overweight BMI should be considered to arrive at a conclusion, and variation of 5 kg plus minus for the minimum and maximum limit may be accepted. So in case of, my lord, for a person, just a minute, if a person is of 165 cm, his, my lord, variation is permissible by plus minus 5 kg. So BMI speaks about, my lord, weight, difference in weight, how to what extent it will be accepted, my lord. Then it says about height, my lord. Similarly, while measuring height fraction of centimeter less than 0.5 will be ignored, and 0.5 cm and more will be rounded off to the next higher cm. Standard height weight chart is attached. This is my higher height weight chart.
Annexure
yes,
one that I have shown, Lordship.
Okay, well, let us go to that, their own annexure, my lord, page 87 in the affidavit. They say, my lord,
This is BMI is body mass index.
for that, my lord, the relaxation is 5 kg.
Should also be considered to arrive at a conclusion and variation of 5 kg plus minus from the minimum maximum limit may be accepted.
Exactly. So for BMI, my lord, 5 kg is tolerated, my lord, either up or down will be accepted. That is the relaxation in case of BMI.
Weight,
It has
basically.
nothing to do, my lord, with the height.
Obviously, you will take care of the height
Exactly.
while in the calculating this body mass index.
Yes.
But it's not a height as such.
Exactly.
BMI.
This weight, 5 kg plus.
This is only to calculate the body mass, to work out the body mass index. Therefore, the weight, the height, the age will be taken care of.
Exactly.
Therefore, that is the different issue, BMI. Now, this similarly, while measuring height fraction of cm less than 0. So and so.
Yes.
So suppose if it is no, if he is not qualified,
Lordship.
as you indicated in advertise, if it's not 65, he's out.
Yes.
Now, what's the question of putting in this relaxation, rounding off?
That,
If you say so,
Lordship, there are
one
other
has to be 165 minimum.
minimum for the state of Assam, Lordship.
Yes, therefore it is, you'll have to consider that at this stage only.
That PST only, Lordship. But this was for annexure 1, Lordship, that page 87. Height in centimeter is also given, Lordship.
Yes, that we have seen. 87.
87 in our affidavit, Lordship.
Yes, yes. we have
This
seen it.
annexure, Lordship,
Yes.
which Says Lordship. Tender height, weight chart is attached at annexure one.
For that annexure one, if we see, my lord, for example, height is, my lord, 164 or 166. In the first column, my lord, will see. So the weight range will be, in the case of 164, 48 to 59. If we now fall back to the OM, my lord, that this weight can be plus minus 5.
Yes.
It may go down or it may
Say
go up.
164.
Yes, this has nothing to do with height. My lord, the relaxation in respect of weight has now been sought to be clapped with the height, my lord. Height is a different acceptor. And if I am rejected at the PST stage, my lord, so the question of issuing that OM and debarring me at that stage and saying that since you are not 165, we cannot relax now because you have to come to this stage.
So though you are rejected, you come to the DMA
Exactly.
to get the
So only possible,
rounding
my
off.
lord, only possible factual situation would be, my lord, that when my PSC was done, I was 165. I have lost my 0.2 mm during the period when I was medically examined. There has to be a loss of height, my lord, in between. Because at PSC, I have to be mandatorily 165 if we go by them. And
So in that case, confirm with this BMI,
exactly.
you may be rejected and in case
Exactly.
of this thing,
Exactly.
if we cannot get the, I mean, difference of the relaxation of 5 kg or maximum 5 kg.
Exactly. Only, my lord, possible situation, my lord, if we consider their argument to be correct, my lord, that a person would have to be 165 at the time of PST and he has himself reduced, my lord, some height at the medical board, then medical board has accepted that change, my lord. That is humanly not possible, my lord. If my lord say, my lord,
Once it is held to be not qualified, no question of DME.
exactly.
Is
my
not
lord,
it? DME is the afterwards.
Afterward.
same argument, my lord.
After when you qualify PST.
My lord, from the same selection process, my lord, cases were instituted in several high courts, my lord. In respect of Calcutta High Court, my lord, I have annexed the order. Same argument was
Just
made.
give me one. Yes.
Page 65, my
This
lord.
was of
My lord, may kindly peruse page 65. That's the order of the Calcutta High Court. Same argument they made, it was negated.
yes.
Applied,
Anything
ma'am.
else? So I have understood what is BMI, what is DME, and what is stage 2, what is PST.
Calcutta High Court order.
So what order can be passed? What happened to that thing?
That Calcutta High Court order, my lord, squarely covers our case.
Saying what?
Page 160, page 65 of the petition, my lord.
Saying what?
It says that analogy that they are trying to give is wrong.
No, it's not. What direction? Suppose if you
Calcutta High Court,
accept your submissions,
my lord.
then what direction we can?
Yes, the direction passed by the Calcutta High Court is that,
Is
in the light, let me read the only one paragraph. In the light of the foregoing, all these writ petitions stand allowed. The petitioner whose height has been recorded in the physical state standard test as 169.05. Their criteria was 170. Here it is 165 cm and above, but below 170 cm are hereby declared eligible for the detailed medical examination board. The response then authority shall act in accordance with the judgment. So this rejection was cancelled and they were forwarded to the medical board, my lord. Detailed medical examination. Same selection process, my lord. Same advertisement, my lord.
Is there any interim order?
No. It's a final order, my lord.
No. In this matter.
No, in this case, there is no interim order.
But must have been filled up.
No.
Post.
Selection process is not complete, my lord.
It's not
yet.
complete.
Not complete. Medical examination is still going on, and my lord, we should be actually basically allowed.
There are different thing. The height,
In
the measurement.
In Assam, it is 165.
No, whatever the petitioners. 164.8.
In
all.
one appearing in one case, item
11, 12, 13.
11, 12, 13. In item 11, my lord, the height of the petitioners are 164.6. Well, I have a chart. I'll just hand over, my lord.
Yes, give the chart.
164.4 is also there in.
Four out.
There is no 160.4, my lord.
Yes, Lordship, in Uttam Baspor 6293.
No, not in our.
No, I am appearing in item.
No, we're taking up disposing of matter together.
Yes, I am appearing in 11, 12, and 13, my lord.
This is start for 11, 12, 13, 14.
14, I am not appearing, my lord. I mean,
Okay. 11, 12, 13, 15.
15 questions.
Just wait.
11 time again.
Huh?
14 bit I am agreement.
No, yours is क्या?
Yes, my lord. Item number 14, my lord.
Just wait.
164.5.
Yours, 15, what about 15?
15, my lord, 164.7, my lord.
Huh?
164.7.
You are in 14 and 15?
14
and 15.
Okay.
14 is 164.5.
You just right. 40, I think 40. 164
That is
point,
earlier.
164
0.5 in 14.
14
Yes.
and
In
15?
15, my lord, 164.7.
164.7.
This is the list, my lord, of item number लिखी थी
You said which one?
Lordship in.
लिखी थी साथ में. In item 11, 12, 13,
Item
these are the
number
petition.
14, Lordship.
Huh?
Second test of 57.
Hmm?
So this year, sir.
So busy as a. Huh? Okay.
My lord, only humble prayer, my lord.
Huh.
My lord, may kindly pray that at the time of dictation, definitely, my lord.
Which
the
one?
Calcutta High Court order. Page 65. That is of
Unnecessary, why?
no, not now, my lord. I'm just referring to page 65.
Or Mr.
P.N. Goswami, my lord.
and Mr.
Isar Ahmed.
H.R. Ahmed, learned counsel for the petitioners. And
May
also
leave
heard
for-
Mr.
may leave for-
S.S. Roy, learned CGC, and S.S. Roy and S. Barua, M.S. S. Barua, learned CGC. Central Government Standing Councils, huh? Or what is CGC? Central Government
Council.
Councils, huh? For the respondents, all.
My lord, may I leave for 5 minutes? I'm just coming. 5 minutes, I'm just coming.
It's okay.
He's there, my lord. He's thorough with the fact.
Is there any rejection? No.
Yes.
Particular rejection order. Just kindly
What happened?
challenge made in this.
It is one item.
These read petitions are to the rejection of what?
Candidate, sir, my lord. At page,
Candidates,
there is a rejection slip, my lord. Page
where it is?
55.
Page?
55, my lord.
$55.
55, my lord. This is the format, right-hand column, my lord, not qualified.
Okay. Whereby the candidates of the petitioners have been held to be not qualified in the PST,
My lord.
physical standard what test?
Examination.
Physical
Test,
standard test
PST.
being below 165 centimeters, huh? Centimeters.
Centimeter.
165 centimeters required for the candidate of state of Assam. Required for the candidates of state of Assam.
My
It's
lord.
only Assam only.
165 is Assam.
Pursuant to the, what is this advertisement?
Advertisement, my lord, dated
Advertisement.
5/9/2024, page 20, my lord, page 20.
5/9/2024.
5/9/2024 for recruitment to the post of my
Issued
lord.
by the, who is this?
It was issued by staff selection
Staff Selection
Commission, my lord.
Commission for recruitment of
constable general duty in Central Armed Forces,
Constable General Duty in Central
Armed
Forces.
Police Forces, and
CAP.
SSF Rifleman General Duty in Assam Rifles,
Hmm.
and Sepoy in Narcotics Control Bureau examination to. These are the
Page
posts.
20, huh?
Page 20 from Sahil Lakai.
The petitioners have also prayed for a direction no, continue, Karan. On the basis of guideline
My
What is
lord,
the
OM,
deadline?
OM dated 25/2015,
no,
page
guidelines.
59, my lord.
On
25/2015.
25.
2015. More particularly, my lord, guideline 2D, my lord.
2005.
Page 63, my lord,
2015.
fine.
You didn't make it, you just write that 2D, huh? Close 2D. Make it close. The petitioners have also prayed, no, and prayed for, not also, and have prayed for a direction to direction to allow them to participate in the further recruitment process by making them qualify with regards to the height by rounding of with regards to the height, huh? By rounding of in the light of said OM. Just correct. This is the only issue we
Only
need to. Just take the facts from here. As the, having considered that the issue involved in these rate petitions are similar on facts and law, same are heard analogously and disposed of by this judgment and order. The case in brief, then you decide, advertisement and then norms. Yes, we'll dispose it,
Deep level.
but I'm not saying
My lord,
will be allowed or not. But I'm disposing, I'm not making it CAB
okay, my lord.
by tomorrow, today or tomorrow. it's-
Page 65, my lord, the
Subject to the-
Calcutta High Court order, my lord. Same argument made, same
Yes.
counter was
Yes.
raised, my lord. Deep level.
কিন্তু হ্যাঁ
Lordship, you were supposed to place it.
ও
Yes,
কেমন ছ Yes,
Lordship, you were supposed to place a written instruction in this
Yes.
matter. The thing is that the office is closed today, so I wouldn't,
why close?
Assam Divas,
Huh?
Assam Divas.
So,
I'm just praying that 2 or 3 days accommodation would suffice. I'll,
Day after tomorrow,
yes, Lordship.
see, once his name is approved, all right,
Yes.
nothing remains.
yes.
Matter ends there.
No, the thing is that I was supposed to place the written instruction.
That's what I'm saying.
Day after tomorrow.
You said on last occasion that your, the name of the petitioner has been
Yes.
approved.
Yes.
So, of course, this Pujari for the finance he said he has no information.
Yes, the finance doesn't.
Who has to approve?
The
Finance.
finance has to approve that. The proposal will be approved by the finance department.
Finance.
That,
You said it has been approved.
yes, it was informed to us by telephonic by telephone. I just need to place the written instruction.
Day after tomorrow.
Okay.
Huh.
Obliged, Lordship.
Or Mr. What is FU
Borboya.
Burboya learn counsel for the petitioner on the prayer of Mr. A.K. Ghosh, learn counsel appearing on behalf of
PNID, Lordship. On behalf of Mr. Keko. On behalf of Mr. Keko for the PNID.
On behalf of
K code.
K code or PNR, then counsel to the peer. K code additional advocate general
Yes, Lordship.
to place to obtain instruction. As regards the approval of the name of the petitioner for payment of minimum scale of pay.
Obliged.
Obliged.
This time, what I say? What I'm saying, can you fix the date? What I said, on the prayer of sunshine. Comma, don't please do, and, comma, let this matter be listed on 40/4/1/2020, right?
37.
Where is 37? Yes, elementary. Huh? Elementary. You are supposed to file,
Supposed to, that's,
who?
SSA,
What SSA?
regarding that.
Who is respond number 3?
Yes, ma'am.
SSA. You're supposed to file an additional affidavit. Hmm? You're supposed to file an additional affidavit.
But I got the instruction yesterday,
Hmm.
detailing how this dice code is issued, whether the SSA got any role in issuing the dice code. That I can file a short affidavit. I got it yesterday,
Who has to clarify this?
By the SSA, we'll file an affidavit, we'll clarify entire process.
Okay, none appears for the petitioner on call. Mr. B. Gogoi, learned. Standing counsel,
Yes, standing council SSA.
SSA,
Yes. 2 weeks.
submits that he has received instruction. No, he received the instructions in regard the pursuant to the order of 17/11/2025, for which he would like to bring on record by an affidavit as permitted by this, and therefore press for a week's time.
Well,
1 week,
let it be 10 days, I'll file the affidavit.
10 days time. This time. Considering that the clarification is required regards the requisite to get a DISC code and the factors essential for provincialization is 10 days time is granted. To Mr. Gogoi to file the good affidavit. And you have to explain
Yes, madam.
what
That I
steps
got
you
the
have
details,
taken.
madam. I have
You
got
have
the
that?
entire procedure, yes.
Okay.
I will place it. down.
10 days.
May it please your lordship.
Yes.
Lordship, this matter, lordship, it had come up on last rotation, lordship. And there is a batch of writ appeals pending, lordship, on this issue.
Hmm.
So this matter may come up after that, lordship. in the month of January. The writ appeal is fixed on 12th of December, Lordship.
Heard Mr. So and so.
That is fine.
Please, Lordship, on last occasion, the district commissioner was impleaded as party, Lordship, and extra copy and not served to us.
Sure.
Please,
Copy nahi.
Mr. So and so, learned counsel for the petitioner submits that the issue, the similar issue in this proceedings is pending before the division
Division
bench.
bench.
Therefore, phrase that matter may be listed after the disposal of
Lordship.
writ appeal.
Writ appeal, Lordship.
Number, you just give.
WA 287 of 2023.
MS so and so learned counsel for this present.
So,
First
second.
of- Accordingly, list this matter after the disposal of
Obliged,
writ appeal so and so. Huh? Just give the number.
Lordship.
May I
Your
please, Your Lordship?
Your Lordship, my senior is in legs in another.
This is listed for order, let us see.
Lordship, we failed to serve the copy to respondent number 5.
Huh?
Lordship, we failed to serve the copy to respondent number 5 because the house was under lock and key, Lordship. We went there 2 to 3 times.
So,
So Lordship allow us to serve the summon through paper publication. Respondent number 5.
So, Your Lordship, my senior is in legs in another court.
which, for which responded?
For respondent 1, 2, and 3.
1, 2, and 3.
Yes.
Who is this, in respect of respond number 5?
5, yes, Lordship.
What you are saying, houses in lock and key?
Yes. Lordship, we went there 2 to 3 times. The house is under lock and key.
If lock and key is there, you can open the lock. So how do you know? You file the affidavit on that. We'll see.
Lordship, kindly allow us to serve the summon from paper publication, Lordship.
We don't know. Okay. On the prayer of, no, Mr. So and so, then counsel for the petitioner submits that despite best efforts, they could not take a stage for service of notice upon the respondent number 5 as the residence of respondent number 5 remains under lock and key, which the on 3 occasions when the petitioner had attempted to serve the notice. Next paragraph. You have taken steps for the by Dusty.
Yes, Lordship.
Have you? This court has permitted to you. Why not the usual process by register AD? See,
Lordship is in page number 39.
no, look at the. You have filed an affidavit.
Yes, Lordship.
What is the affidavit? There is an objection also. Who has filed the objection to the affidavit? Mr. Therefore, he says that no, you have to delete everything. Submits that. No. The learned counsel for the petition of Mr. So-and-so by has filed the affidavit to affidavit in support of his inability to serve notice upon respondent number 5 by Destimot. Mr. Peruzet of the affidavit indicates that the petitioner has made an attempt to serve the notice on 2 occasions, i.e. 0709-2025 and 0909-2025. But on the house of the residence of the petitioner under lock and key, therefore could not serve the petition, I could not effectuate the notice upon respondent number 5. In view above, in such situation, and please, under such circumstances, learned counsel for the petition submits that he may be allowed to take steps through paper publication. Next, considering above, the petitioner is allowed to take steps by paper publication into daily newspapers widely circulated in the area. She's from where? Respondent number 5 is from
Hailakandi.
in the Hailakandi district, huh? Within 10 days from today, at least after 3 weeks, 4 weeks.
Item 22.
Possible.
Part hard matters, my lord.
It's a pattern matter.
Yes, my lord.
Huh.
Very simple question, my lord.
Huh.
The question is whether the government was entitled to recover by way of Bakijai proceedings, my lord. 3 questions, my lord, to refresh my memories, my lord. 3 questions fallen from this court, my lord. 1, whether I have deposited the security amount, my lord, whether I have paid the first case, and my lord, whether we have entered any agreement, and then finally Mahal was handed over to me or not. This was the questions, my lord. The query of the court was, my lord, to justify that it was not done, my lord, the page 15, that Mahal.
15.
Page 15, my lord. This was the final settlement order in my favor, my lord. Page 15. By this letter, my lord, I was asked to deposit security amount 14.150 and the first kiss money 35.125, my lord. Additionally, sale tax and additional tax, my lord. Now, straighten away, my lord, page 42. That will give us an indication whether I have paid this or not, my lord. Page 42, my lord. The second paragraph, my lord. In the above context, the Mahal was settled with C so-and-so, dated so-and-so, but the settlement holder did not deposit the security money first case, my lord. The first two questions, my lord, even though the settlement was done in my favor, I was failed or I have not paid the first case and the security money, my lord. Naturally, there was no agreement, my lord, executed, and my lord, Mahal was not handed over to me. Now, my lord, can peruse page 54, my lord, for a moment.
50?
Page 54, my lord.
Yes.
By this, my lord, I am going to demonstrate that the first case money, the fourth line, my lord, earnest money as per the tender rules within the stipulated time. Therefore, the Mahaldar contended that he is not liable to pay the revenue. In this context, you are requested to clarify the matter as how the San Mahal was selected with so-and-so debtor along with the signed agreement paper within 7 days from the date of receipt of this letter to take appropriate actions the defaulter from this end, my lord. So the whole question, moot questions is, my lord, when the settlement was done, thereafter I was asked to deposit the security amount, first case, and then, my lord, entering into an agreement part. Now, what they have done, my lord, instead of cancelling the notice, my lord, straight away, they have taken the resolution of Rule 17, my lord. Now, my lord, page, if you, my lord, can have this book, my lord, Assam Forest Manual, page 65, my lord. Only rules, my lord, contemplating the cancellation of the bid, my lord, for resale, my lord. Page 65, if you are holding this, Assam Sale of Forest Produce Couples and Mahals Rules 1977, my lord. Rule 17, my lord. Very clear that this Pakizai proceedings is, my lord, cannot stand the scrutiny of law and it is liable to be interfered by this honorable court, my lord. That's what is my prayer is. My lord, on the last occasions when the matter came up, my lord, three things was required to be demonstrated before this court by this learned state council, my lord. One, whether I have paid the first case, whether the security deposit was paid, whether we have entered into an agreement, and finally Mahal was handed over to me or not, my lord. These four, the whole questions.
Which rule you are referring?
17, my lord. Cancellation and resale for failing to pay the security installment and to execute agreement, my lord. May I read it, my lord? The small paragraph, my lord. The gist of this, my lord, in the absence of first case security deposit and not making and entering into an agreement, my lord, Bakibjai proceeding cannot be initiated against anyone, my lord. Now, my lord, first, starting from the first line, my lord, if the tenderer whose tender has been accepted fails to pay the security or to pay the installment on dues, to pay security to pay the installment and dates mentioned in Rule 15 and to execute agreement mentioned in Rule 16, and the sale of the couple or mahal shall liable to be cancelled, and the cope or the mahal shall be resold for the remaining part of the couple or mahal, period, at the risk of such tenderer as regards the loss of the government, and if the proceeds or the resales are less than the value of which this originally sold, the difference shall be realizable from him, and further the earnest money shall be fortified, and the whole and the fixed security deposit or part thereof, as may be necessary, shall be adjusted against the dues. Now, my lord, the second part of the paragraph case law, my lord, Rule 7, mahal could not be resold by issuing a resale notice, fresh sale notice after confirming the requirements of Rule 4 required to be issued. Now, my lord can turn to this book, my lord. This is in the same book, my lord, page 57, Sale and Tender, Rule 4, my lord. My lord is on, my lord. Tender notice, my lord. Again, only one paragraph is required to be. Yes, my lord. Brief notice for tender. Brief advertisement inviting the tender for sale of mahal timber lots containing the names of the mahal lots, area of the mahal, quantity of timber, period of lease settlement, which shall not exceed 2 years along with the date. Time and venue for receipt of such tenderer shall be published in the local daily newspapers for at least consecutive 2 days by the divisional forest officer at least 1 month prior to the last date fixed for the submission of tender, stating that the details of the mahal, lots, and other terms and conditions shall be available in the sale notice, which can be procured from the office of the divisional forest officer during the office hours and any working day on payment of so and so, my lord. Provided, my lord, for the resale of any mahal or timber lot, publication of short sale notice at least 15 days before last date of receipt of such tender shall be made, which may or may not be published in the newspaper, my lord. And then case law, my lord, rule 4. Now, my case is, my lord, when they have resorted this resale, my lord, mahal was not settled with me. It was only a letter of settlement that was issued to me, whereby I was asked to deposit the security money first case, which I have not done. And thereafter, naturally, here the rule 718 agreement part, my lord, when I have not paid the first case and the security amount, my lord, naturally, I have also not entered any agreement with. And thereafter, they have also not handed over the mahal to me, my lord. Now, agreement part, my lord. Same rule, my lord, 16. An agreement as formed in the appendix shall be executed within 1 week of the payment of first installment and the security as mentioned in rule 15. The mahaldar of the contender whose tender has finally accepted by the government authority, my lord. Here, I am repeating my line, my lord. I was asked to pay, for whatever reason I have not paid. First case, my lord, security money, agreement not entered, and mahal was not handed over to me. In the absence of these 4, my lord, whether Bakijai proceedings as far as rules are concerned, my lord, I have demonstrated that the Bakijai proceeding is bad in law, my lord. Now,
This is which rule? Assam?
Assam, page 65, my lord. Assam, sale of forest produce, couples and mahals rule 1977, my lord. Now, my lord, how this honorable court has held in a situations where after the settlement, a man has not paid the first case, not paid the security amount, not entered an agreement, and finally mahal was not handed over. In that situation, my lord, 5 cases of this honorable high court I am relying, my lord. The authorities are, my lord, Bijaram Ingti, my lord. The similarly situated situation has held by this and said money is not recoverable under Bakijai proceedings, my lord.
So according to you, although offer was there, you
Yes,
were
my
the
lord.
highest bidder,
Yes, my lord.
but then since you have not paid, there's no agreement.
Yes, my lord. Here on the face of record, my lord, two documents that my lord I have demonstrated. 54 is very important. There it's categorically mentioned that I was, for whatever reason, my lord, I have not paid this 4 mandatory part, my lord.
No, this is the letter to the 54.
Yes, my lord. Page 42 and 54, my lord. Admitted position as far as this record
Inviting
is.
referential letter, so Abdul Rahim so and so. Allege that this is your statement, no your other case only. Allege that he did not execute any agreement for settlement of the same amount, nor he deposited for so and so as per the tender rules within the scheduled time. Therefore, the amount of content that he is not liable to pay the. Maybe in this context, you are requested to clarify. This is your statement
Yes.
has been recorded.
Yes, my lord. Here, my lord,
So it's not established. It is your statement which has been recorded.
Okay, and then page 42, my lord, have a look, my lord. Page 42, my lord. It is their document. Even page 54, even though it's my submission, my lord, but it was recorded by an additional deputy commissioner, my lord. Here, page 42, my lord. Settlement holder did not deposit the security. Second paragraph, ultimate line, my lord.
Yeah, who is this?
This
Divisional
is
forest.
divisional forest officer to additional deputy.
To sell on so and so Abdul Rahman Hyper Highest Beach so and so, the above 100 mile was settled with Abdul Rahman. 31-7 is what? What is the settlement?
The
The
first
settlement holder did not.
page 15. By this letter, I was asked to deposit, and page 17 is the settlement order.
Then what happened thereafter?
Here, thereafter, instantly Bakijai proceeding was initiated against me, my lord.
Okay, what was any proceedings?
Yes, my lord. Page 57. Straight away, my lord, without contemplating and following the due process of law, my lord.
What? What due process?
Process is 17.
Recovery
50.
of outstanding certificate officer.
Yes, my lord.
Huh?
Recovery of outstanding.
56 is there. This is the type copy.
50, if type copy is the
Deposit
original is
entered
57.
outstanding government dues amounting so and so, to the understand by so and so, failing which you are normally going to be trust and also warrant of arrest will be issued against you. Huh? No proceedings is required.
That is what under challenge, my lord. This Bakijai proceedings initiated against me.
So,
to
yeah,
recover.
what are the grounds? Tell us.
My first ground is, my lord, I have not deposited the security amount, page 17. The same first kiस्त I have not paid. I have not entered any agreement with the authority, my lord, and Mahal was not handed over to me, my lord. And as far as law is concerned, my lord, I am relying these judgment of our High Court, my lord, whereby it was held that, my lord, in the absence of these 5 mandatory requirements, Bakijai proceedings cannot be initiated against me, my lord.
So once it is not settled by way of agree, yes, once it is not settled,
yes, my lord,
even though you are found to be, or even you have been offered, if it is not followed by agreement and payment of security and anything, it's
Yeah.
not, cannot be said there.
Bakijai proceedings cannot be initiated against me, my lord.
How many? How many cases?
5 cases that I
Why
have.
5 cases? Only one will do.
Only one, my lord, Bijaram Ingti, paragraph 7, 8, and ultimate paragraph 8 is very long, my lord, 9. Only ultimate paragraph of Bijaram Ingti will give you a light, my lord, that this Bakijai proceedings is bad in law, my lord.
This is what?
This is against the recovery procedure, my lord.
7, 8, 9. Para?
17, paragraph 9, my lord, and ultimate paragraph, my lord. Page 10 and paragraph 10, my lord.
$1981.
Yes, my lord.
82.
One of the leading case, my lord, as far as Bakijai proceeding is concerned, my lord. 9 and 10 will give an indication, my lord. Clear finding.
Para? 9.
9 and 10, my lord.
Then?
Then
Para 9 and 10 only.
yes.
Rest?
Rest on the same footing, my lord, same line. Bakijai, when there is no keys, no agreement, no handover, my lord, Bakijai proceedings can be initiated, my lord. The second, it is all are small judgment, my lord. The second judgment I am relying in Bijoy Deka, paragraph, my lord, paragraph 11, my lord. 11 and 16.
That's all.
This is my submission, my lord, as far as this Bakijai proceeding is concerned. This cannot stand the scrutiny of law and is required to be interfered by this honorable court, and I am praying for interference, my lord. This is my humble submission, my lord.
I may see page 15 of the petition, ma'am.
15.
15.
Yes.
The second paragraph, my lord.
Hmm.
Please arrange to deposit the security money and first kiss of the Mahal within 7 days from the date of issue of this letter, as noted below, and came up for signing the agreement in this office. In the event of your failure to deposit the same within stipulated time, the Mahal will be put to risk sale at your risk as per conditions of the relevant sale notice.
Hmm.
Then my lord may see Rule 17 of the 1977 rules, my lord, which
He has referred.
yes, my lord.
Hmm.
Rule 77 says cancellation and resale for failure to pay security and installment and to execute agreement.
Hmm.
So failure to do either of the three, yeah, this one covers, my lord. My lord may see the exact wording. If the tenderer whose tender has been accepted fails to pay the security or to pay the installment on due dates mentioned in R.5 or to execute the agreement mentioned in R.16, the sale of coup or the mahal shall be liable to be cancelled, and the coup or mahal shall be resold for the remaining part of the coup or mahal period at the risk of such tender as regards the loss to the government. And if the proceeds on resale are less than the value at which it was originally sold, the difference shall be realizable from him. And further, the earnest money shall be forfeited, and the whole of the fixed security deposit or part thereof as may be necessary shall be adjusted from the dues. Then, my lord, may see Rule 18, mode of realization of arrears of sale value. Any amount due under these rules shall be recoverable as arrears of land revenue. Hence, my lord, the Bakijai proceeding. And Bakijai proceeding is, my lord, initiated under the Bengal Public Demand Act, my lord. That is a whole code in itself. It has provisions of appeal, revision. Actually, my lord, he should have gone to the revenue board to appeal against this. But my lord, yeah, so far records say that he has also not gone for appeal. And my lord may have seen in the earlier rule, Rule 17, there was a word risk sale. What is risk sale, my lord? Because it was settled to him after a proper tender process. He then does not go ahead with it. Then what happens again? Mahal has to be put to sale in an immediate basis, just to compensate the government, because that is loss of exchequer, my lord.
You tried, but there was no taker.
Yes, then my lord, that
failed.
loss,
Resale failed.
hence, my lord, this loss will have to be borne by the
According to you, if it is fail also, if the tender whose tender has been accepted fails to pay the security.
Yes.
What do you mean by this acceptance?
It means when it is settled, my lord, finally settled.
What do you mean by settle?
Settle,
Unless there is the agreement.
agreement, my lord, comes next. When he deposits this money, security, he has not done it. That is why, my lord, this rule says failure to pay security installment or to execute agreement. So not executing agreement is also a violation of
What
this
is
rule.
it? The has been accepted, fails to pay the security or to pay the installment on the due dates in Rule 15 or to execute agreement mentioned in Rule 16. Okay, the sale of the bond shall be liable for cancel, and the coup or the mandal shall be resolved for remaining part of the or mahal period at the risk of such tender as required state loss to government. Yes. Yes. Continue.
Now, because he did not go ahead with the mahal, ultimately there is also loss to the state because he has to pay a regular kist money. So that is why this code has.
Since he has failed to pay the security amount or the kist amount,
Yes.
as well as failed to, enter into an agreement which has
Yes.
led to loss of the state revenue. Therefore, you tried to have sell it. It could not be resolved, which again incurred
My lord.
loss to the
Loss.
state revenue, therefore, you are recovering. By Bakija. Now wrongly or rightly, Bakija has issued a certificate, right? The certificate has been issued,
Yes, my lord.
therefore it is an appealable order.
Appealable.
Under which section?
Under my lord.
Bengal recovery so and so.
Under my lord.
'54 of the Bengal Recovery,
Recovery.
Public Demands and Recovery Act. my lord.
Just read it. Read.
Any, first, my lord, we have 54 review. Any order passed under this act may, after notice to all persons interested, may be reviewed by the officer who made the order or by his successor in office on account of mistake or error either in making of the certificate or in the course of any proceedings under this act. Then we also have, my lord, revision 53, my lord. Revision is collector may revise any order passed by a certificate officer, assistant collector or deputy collector under this act. The commissioner may revise any order passed by a collector under this act, and the Board of Revenue may revise any order passed by a commissioner under this act. The period of limitation, then we also have, my lord, 51 appeal. An appeal from any original order made under this act shall lie if the order was made by an assistant collector or a deputy collector or by a certificate officer not by a collector to the collector. If the order was made by the collector to the commissioner, provided no appeal shall lie from any order made under section 22. So here, my lord, the order is
Not under section 22.
22 says, my lord. '22 says application to set aside sale of immovable property on deposit. Here it is, my lord, no, not applicable.
It's a pure and simple recovery.
Yeah.
Pure and simple recovery.
Simple recovery.
That the specific question raised by learned friend has been adequately answered by the judgment that I am relying, my lord. Paragraph 16. Only 2 lines of, my lord, that will give indication, my lord.
Which one?
The
In
first
P.
judgment,
Ram.
Bijoy Deka, my lord, versus state of second judgment, my lord. Bijoy Deka. Paragraph 16, my lord. The decision of Chawan Musahari versus state of Assam, so and so, does not render any assistance whatsoever in the matter. In the said decision, the court observed that very word resale would signify an act of earlier sale. Admittedly, the mahal in question was not sold pursuant to the sale notice dated so and so. In such a situation, it is difficult to appreciate as to how the mahal could have been attempted to be resold by using a resale notice dated so and so. Having taken the view indicated, it is only a logical view that would arrive at the conclusion that the mahal could not have been attempted to have been sold by publication of a resale notice dated so and so, and what should have been done in publication of a fresh sale notice after confirming the requirement of spelled out by Rule 4 of the rules, my lord. This decision upon which the learned Senior Council, my lord. So my contention is when Rule 17 says resale, my lord. Resale has to be read with Rule 4.
This is declaring resale and all.
Yes, here rig sale, my lord. The procedure is rig sale and resale is 17, my lord. For the resale, my lord, procedure of publication of the notice and fresh notice is mandatory, my lord. For rig sale, my lord, I have to put in a notice, my lord. The language indicate of 17 is after the cancellation. When the line number 5, my lord, liable to be cancelled. Now, when the cancellation is done, my lord, or required to be done, my lord, procedure 17 and 4 has to be followed, my lord. The procedure here is, my lord, fresh publication in the newspaper, my lord. Here, my lord, on a specific query was on the last occasion, whether this procedure are followed while contemplating for resale or rig sale, my lord. The learned council has applied replied, my lord, saying that there was no paper on record to demonstrate that it was followed, my lord. Even on 17, my lord, I have a case, my lord.
How?
My lord, the procedure was not followed. Here, publication of newspaper is required, my lord. Procedure followed, my lord. I required to be get a notice, my lord, why and how they are going to differentiate on what basis that the resale amount will be calculated, my lord. I am not on that, my lord, because as far as procedure is concerned, their Bengal demand is, my lord, public demand. I need to get a notice that this was the settlement amount. Now we got the offer, and then the offer is less, and we have calculated it. No such calculation was presented, my lord. Straight and way, without following the procedure, my lord, gone to the Bakijai proceeding, which is bad in law, my lord. And my lord, Bakijai proceeding cannot be initiated against me in the absence of a written agreement, my lord.
Resale, there was a resale
Attempt.
Resale was made, but there was no takers.
There is no taker, my lord.
Then
So, my lord, when there was no taker means the representation that I have given was also not considered, my lord. This is on record.
what is your representation?
Representation was, my lord, I am a new, that time, my lord, 25 years back, I was new. I have not gone and physically inspected. When I have physically inspected, I found that with this amount of money, this mahal for me will not be economically viable. And that's why on that economic viability, my lord, I have written a representation. And initially it was considered, my lord, I can
It was
demonstrate.
cancelled or what? Not cancelled.
No, Mansal, once it is cancelled, my lord, Bakijai proceeding cannot be initiated. My lord, that's the moment.
Second sale did not happen, my lord.
Hmm.
Therefore, my lord may see at page 33, entire bid value is sought to be recovered from him because that is the loss to the state because resale could not happen. Exact amount, my lord, which he offered, that is being sought to be recovered. Page 38 will make it clear, my lord.
Yes, why no appeal? Why appeal was not?
My lord, my respectful prayer will be to look at the page 37, my lord. Initially, the department was convinced that I have a case, my lord. Page
No,
37.
it's okay, it's okay, it's not that.
My lord, my respectful prayer will be.
So ultimately, this is an appealable order.
This is an appealable order, my lord.
Then
But see, my lord, here why I'm seeking a writ jurisdiction, my lord, because I have not followed this RICS procedure, my lord. I have not fulfilled the criteria. Past case, security, agreement, and no handover taken place. Place 37, my lord, have a look, my lord. Initially, it
so
was.
this is a ground for resale. It's a ground for cancellation and resale.
Yes, my lord. For resale also, they have to follow the procedure 17, 4, and 18, my lord. They have not done. My lord can ask my landed friend to demonstrate whether they have followed the procedure or not before going to the Bakijai proceeding, my lord. That is my case, my lord. My lord, my respectful prayer will be to see page number 37 for a moment, my lord. Initially, the department was convinced that I have a case, my lord, and that's why it was put on hold, my lord, for some time.
No, that we have seen. That is not for the warrant of place 37.
Yes, my lord.
We have seen it already.
My lord, my respectful prayer will be to once again, my lord.
37?
37, my lord. RICS sale was put to hold for some time, my lord. As directed to enclose here with a copy of the prayer petition, my lord, so Goalpara, and to request you to kindly stay the RICS sale dated so-and-so, the Domini River and Mahal so-and-so under Goalpara division, and to furnish detailed para-wise report in the matter along with the comments of the Chief Conservator of Forest, my lord.
Prayer for stay of risk sale. This is by you.
No, my lord, Under Secretary Government of Assam, Environment and
Stay
Forest
of risk
Department,
sale, that is so and so.
way back 2004, my lord.
To request you kindly to stay risk sale, that is so and so, all the under Golfer.
This was done at my behest, my lord. Abdur Rahim has submitted my representation, my lord.
It's a internal communication.
Internal communication, my lord, Divisional Forest Officer from Under Secretary Environment, my lord. Based on my behest, my lord. Second line, my lord, Abdur Rahim, I have submitted my representation, detailing everything, my lord. My lord, second line, I'm rereading, my lord. I am directed to enclose here a copy of the prayer petition dated so-and-so submitted by Muhammad Abdur Rahim, who is the present petitioner, my lord. So by this, what I am going to pursue, my lord, is that initially the department was also thinking to halt for a moment because to consider my representation. Ultimately, they have not considered my representation, my lord.
Said golfer and to request you kindly to state the risk conditions of the nation under golfer and to furnish detailed particular reports in the matter. Yes.
This is my case, my lord. Both the rules is in my favor, my lord. Facts is in my favor, my lord. The authority that I have placed, my lord, for 5
So
authorities.
how this Bakizai was just this proceedings has to be followed in Bakizai?
Here, first will be Rule 17, madam. Failure to pay security installment or execute agreement. None of these are done by petitioner. So then we move on to, my lord, Rule 18. Mode of realization of
Yes, it's okay. Then in the Bakizai proceedings, what is to be the procedure?
In Bakijai, my lord, we send a communication to the certificate officer saying that this much amount is due to the government. So it needs to be realized. Then, my lord, the deputy commissioner offices Bakijai branch, they issue a notice to petitioner to participate. He's supposed to, my lord, deny the liability with the petition. Then a hearing is supposed to take place, my lord. After hearing, the order is passed.
Whether that has been followed or not?
Here, he has submitted his prayer petition to the Bakijai officer also at page 50. And my lord may see completely different grounds, my lord, nothing with regard to what has been argued right now. One, they are saying there was no alternate road, so I could not operate. This is the only thing, my lord, raised in this one.
Notice was issued? Any notice?
Bakijai notice was issued to me, my lord. As far as procedure, my lord, is wanted to know what is the procedure in Bakijai procedure. As a counsel, I have personally conducted the case, my lord. The procedure is, in this kind of cases, my lord, initially the deposit amount, the certificate amount, and then thereafter how they have come to the conclusion that the rig sale was. If it is difference, my lord, up I have to pay, less I have to pay, my lord. That calculation was not there. My lord, specific questions was
First that you have been issued notice, whether you have issued received the
that
notice.
document is not with me, my lord. My lord, specific query was
Prayer
the
for
last.
release from the certificate case. Obviously, you might have received the notice.
That part, my lord, as far as my learned friend is concerned, my lord, he will be able to apprise this court whether the records indicate that I have participated in the proceeding or not. As far as first letter goes, my lord, yes, notice was issued to me, my lord. So my respectful prayer will be, my lord, at this stage.
You are not challenging the procedure.
Bakijai
No,
procedure.
you are not challenging that in the Bakijai proceedings, no procedure was followed.
Here I have also taken a plea, my lord. The Bakijai proceeding is bad in law.
How?
Because of 17, 14 was not followed.
That is different. You're not, there's no, you have not taken any ground that the Bakizeh proceedings
Yes, my lord.
as such was not procedure for
Procedure as far
was
as,
not followed.
yes, as far as Bengal demand is concerned, my lord, it was not followed. That specific pleading is not there. But I have challenged the Pakija certificate on the ground that while issuing the Pakija certificate, the procedure as far as mandate of resale and risk sale is concerned, not followed, my lord. Hence, ultimate conclusion is Pakija certificate, which is bad in law, my lord.
Therefore, you could have filed an appeal.
After 20 years, my lord.
No, that is that time. We'll talk about that time only. Not now.
I have,
Since you have not, there was an alternative remedy.
yes, my lord, which I have denied.
And when
My-
did you file this writ petition?
2018, my lord.
18.
Yes, ma'am.
What is this certificate? Certificate
57.
is of
57, my lord.
2017. Okay. What 20 years? Against
No.
this you have to file an what is this order, other orders? Any other order?
No, my lord. I was communicated with this, and then the attachment and warrant act will be issued against you, my lord. The last line, my lord.
Will be issued against you.
Movable, immovable property will be attached, and also warrant of arrest will be issued against you.
So nothing has happened.
Nothing has happened, my lord.
Any stay order?
Here, yes, my lord. Stay on the motion stage itself, my lord. Nice. 9 to 18, my lord.
Because my lord, only till the returnable date, my lord. The last orders have not extended the interim.
No, we'll not go into all this. No.
Extend until and
Have
unless
not
it's
done
not-
anything.
As far as read procedure is goes, my lord, until and unless it did not specifically cancel, my lord.
No. But then what about this appeal?
My lord, my respectful prayer will be, as far as record goes, my lord, definitely there are some lapses on my part, but since I have not participated, not deposited, not security deposit was not deposited, mahal was not handed over, agreement was not executed. My lord, I do understand, my lord, as far as this years is concerned, my lord, this required to be interfered, my lord, by this honorable court on this ground, my lord, since I have not benefited from this and my representation was not considered initially. There was initially some consideration was there, finally it was end up with zero effects, my lord. So my respectful prayer will be at this stage, and I am not, since I am not on record, my lord, the petitioner is seriously ill. He is suffering from.
But how can you issue just directly a recovery order? Communication.
This is a, my lord, recurring issue with the DC's office, my lord. Pakijai proceedings, they just lie in dust, my lord, until something happens, something in motion is set, then again notices are set. But can it, my lord, give right to right to any individual to, my lord, cause loss to the state exchequer, my lord? That is one.
No. If the procedure is provided, you have to follow.
Procedure has been followed, my lord.
How?
Demonstrate.
It's only that you have made approach the Bakizeh certificate officer. And it appears to be on one notice was given, then subsequently you have just issued the certificate.
And the petitioner participated also. Records show, my lord. He has
No,
submitted his
participate.
letter.
How you have how the certificate officer could come to a conclusion? On what basis?
Then my lord, records will be required from the deputy commissioner, my lord, because records are incomplete in this writ petition.
Who is deputy commissioner? Is a party here?
Government,
Is a party here?
Yes, my lord. The respondent goes, my lord, additional deputy commissioner. Bakija branch. On this record, my lord, as far as order of this honorable court is concerned, my lord, record was called for a number of occasions, my lord. On the last occasion, my learned friend submission was because it was not complete, my lord. Whatever document is available, my lord can ask my learned friend to.
No, this proceedings in the Bakija,
Right, my lord.
it should be by the additional deputy commissioner only.
government.
On the face of
The
record.
last occasion, there's a,
My lord, as far as my.
it was
memory goes-
recorded that the records have been received.
Yes, my lord. That's what I'm.
Records from deputy commissioner will be received by my lord, their council.
6 and 7. Who is 6 and 7?
Government advocate. will-
6 and 7 Deputy Commissioner Gwalpara, 7 additional Deputy Commissioner Bakija branch.
Yes, he appears to have the record. Where is government advocate? Yes, madam, you are for? You are appearing for? State. Who are the states? 6 and 7 is also not part of the state. It's a part matter. Today is not done. Vijay Talukdar. See, Mr. Borthakur, there may be reason to initiate, but the certificate officer has to follow certain procedure under the Bengal Act.
Records will be required, my lord, because I.
So last time it is, although it is seen that the records have been received. How this has been, I don't know. Since none is present on behalf of the Forest Department, Learning Council restaurants place the records on the next date. So you're supposed to place the record.
Forest department, I am there, my lord, but PGI records will be received by their council.
My lord, may I come back for a second, my lord? What my land, instruction for the records, my lord. Record is for the Bakijai proceedings, my lord. On the face of it, as far as record of this procedure is concerned.
Heard Mr.
A.S. Tapadar, my lord.
Yes, the father, learned counsel for the petition. And also heard Mr. I. Botakul, learned standing counsel. Forest Department for respondent number
1 to 5.
1 to
5.
5. Ramesh Swainso, learned counsel, state council. Appeals for. Your state council. 6 and 7. I'll record that you, despite repeated orders, the government, the respondent 6 and 7 have failed to produce the record. We'll record that in the order, huh? Are you getting? Hearing concluded, judgment reserved. Give us this, please, sir.
I'm deeply obliged, my lord. I'm deeply obliged.
Yes. Both the case, both the books. Yes, yes.
Yes, please, your lordship. Well, I have appeared for item number 23 and 24. My lord, these matter pertains to my lord, the release of the petitioners.
23?
23 and 24, my lord, I have appeared. My lord.
Kadir.
Yes, madam, Kadir.
Kadir. Yes.
Matter pertains to my lord, release of the petitioner from the contractual service of the NRC updation project, my lord, in the state of Assam.
Still going on?
No, my lord, it is.
It's over.
Or not over, it is not officially declared that it is over. And the matter was.
NRC is still going on?
Yes, yes.
Yes.
That is our case, we are challenging the termination orders. Now they have terminated some and kept some. It is still going on and many things are left. The rejection slips are left, lordship, and as per the statute also, it's a continuous process. It's like birth and death. There is a statute governing it.
But we are not on the procedure of that NRC. You are, it's a termination of your contractual service only.
No, lordship, for that also, there is a procedure.
What do you want?
The lordship, now there are developments. I want to bring it on record, lordship, 1 or 2 days, lordship.
What development?
Lordship, what has happened now, their point is that it is complete, but they are keeping.
No, whether it's complete or not complete, it's not a matter. You are a contractual employee.
Yes, lordship.
What is your right to continue? That's all. We'll see that. We'll determine that.
Yes, lordship.
The continuation of NRC proceedings, I mean, all these things, it doesn't have any bearing on it.
Lordship will fix it on Tuesday. Whatever it is, I will bring it on record. Lordship.
What development you want to bring?
Lordship, in 2025, they have again continued the rest of the employees, but it is there. Their point is that it is complete, but it is not like that. Lordship, it might have
They've
some years.
engaged new employees, contractual employees.
Yes, Lordship, they have continued it with the earlier ones also.
You are also continuing.
No, Lordship, we are terminated.
There's the stay order.
There is a stay order. In violation of the stay order,
The stay order, my lord,
they have
terminated.
terminated.
In fact, till date, the stay order operates, my lord.
So,
So we are out of job. Lordship.
out of job finish. Contractual. Go for better job.
Not
today.
Not today, Lordship. On next Tuesday, Lordship can hear the matter, and I am led by Senior Counsel Mr. P.K. Goswami will appear.
There is also same submission.
2020 matters, my lord. Already about 6 years going on, my lord. And
20 matters.
yes, my lord. The matter listed.
Our is.
My learned friend wants to continue, my lord. His matter is totally different. He's not, in fact, it's tagged together. I don't know why. It was detagged earlier, my lord.
What is this? Why? Your matter is what?
My lord, same.
Grade 4 employees, my lord. Whereas I'm the junior assistant and he's the superintendent, my lord. We are
Circle
covered
for
by a service rule. And so far as my learned friends, clients are concerned, my lords, there's no service rule, my lord.
Wrong, my lord. It's a wrong submission, my lord. All the
Okay,
employees
first
are
you
covered
decide
with the same
yourself.
service rule, my lord. I do not know why my friend is submitting a wrong submission, my lord.
Anyway, huh?
The same service rule is
Oh, next
governed by
week,
all the, why are you
Tuesday,
submitting
Tuesday.
in
Next
a
Tuesday,
wrong
Lordship,
submission, my
Lordship will
lord?
hear the matter
Ah.
for a fight.
This is a listed for
The
hearing
issue
only.
is same, my
He
lord.
listed for
The
hearing.
issue is same. The designations are different, my lord.
So
Designation
according to you, you are also appointed on contractual basis.
Yes, my lord. That's
In a grade 4.
Yes, so grade 4.
And you
They
have
are-
been terminated.
Yes, they are
By
assistant, sir.
providing 3 months notice. Notice.
Yeah,
One
they are-
month notice.
1 month
One
notice
month
in
notice.
terms of the agreement, terms of the appointment.
Yes, my lord.
In terms of the appointment order.
Yes, my lord, but service rule is violated, my lord.
Huh?
Service rule is violated. Service rule is different, my lord. As per service rule, we cannot be terminated, my lord, like the where they have terminated, my lord.
You said, they said this
Same
was
service rule is there, my lord.
for grade 4.
Yes.
It's a service rule for contractual appointment.
Yes, my lord.
Where is the rule? Let us see.
It's
Yes, yes,
all
my
the service regulations 2014. Its name is National Register of Citizen Updation Project Service Regulations 2014. Under clause 8, there is a procedure, how will terminate. There will be a self-appraisal report, A to D, they will mark. Thereafter, whoever gets D, they will be terminated. But arbitrarily and discriminatorily, they have terminated us, keeping some.
That is your case. So if that is not been exercised, if rule is not followed, we'll say that we'll set aside this termination and send it back
Yes.
to liberty, the authority to
Follow the rule.
follow the rules.
Yes.
Within a month, again terminated.
As per rules, my lord, they cannot terminate, my lord. The rule is there, after appreciation, my lord, if we are found that we are graded as C and D, if D is the graded, then the termination is there. But we all are A and B, and the rule is silent regarding A and B. Only C and D, if the apply appreciation, if the grade is D is given, my lord.
What
then
is the law that once you are appointed on contractual basis, your service cannot be terminated? What is the rule?
My lord, service rule, governed by service rule, my lord. The regarding termination, the service rule is, my lord, clear, my lord.
Yes, Lord.
Service rule.
You said without following the rules.
Yes, my lord.
They have been you
Yes,
have
my
been
lord.
terminated.
Without following the rule, we have been terminated, my lord. This is our case, my lord.
Not Mr. So and so, all of them. Just give your name.
BP Bora.
Serially will say,
Yes. I am for MJ Kadir for 23.
MJ Kadir. 23-24, huh? And
P Mohata for 25 months.
P Mohanta 25. Then BP Bora
For 26-27.
26-27, huh? As agreed to by then to the parties, let this matter be let these matters be listed on
9th.
9th.
Actually, 25 months, there's an interim order.
Interim order passed.
In
Yes,
27 also.
Shall continue.
27 also.
We'll just say interim order passed earlier shall continue.
Yes.
This item 20, all the items.
Not all.
No, not all the items.
25,
And 27.
25, 26, 27.
25 and 27.
27.
25 and 27.
27.
Interim order passed in WPC 2831 and 3148 shall continue.
Deep blue.
May I place your honor? May I place your lordship?
Yes.
Lordship, this is a case of compassionate appointment, lordship, of the petitioner whose father was died in harness in the year 1998. Accordingly, within 1 month, the petitioner submitted an application along with all testimonies.
1998.
Yes, lordship. Thereafter, in 2012, lordship, after almost 14 years, lordship, the DLC sent a recommendation to the SLC, lordship. Thereafter, as
no information was received by the petitioner from the DLC. Lordship, thereafter the petitioner filed an writ petition before this honorable court. And in the writ petition, Lordship, the government has submitted a minutes of meeting of the SLC held on 27/11/2015, Lordship, where it was stated that application for compassionate appointment of the petitioner has been rejected on the ground that there are no further vacancies. While disposing the aforesaid writ petition, Lordship, the honorable court at page 31, Lordship, we have annexed order of this honorable court, Lordship. It has been stated by the State Council that has submitted that the meeting minutes of the SLC held on 27/11/2015, which shows that the application of the petitioner for compassionate appointment has been rejected on the ground that there was no further vacancies. And it was also specifically mentioned by this honorable court that it is needless to add that the petitioner is at liberty to challenge the meeting minutes of the SLC dated 27/11/2015 as per law, if so advised. And accordingly, the petitioner has approached this honorable court by filing a writ petition challenging the minutes of meeting dated SLC dated 27/11/2015, Lordship. Therefore, Lordship, what happened? A batch of writ petition was disposed of by this honorable Guwahati High Court. And the honorable High Court
challenging the office memorandum.
Yes, Lordship.
2024.
Yes, Lordship.
Huh?
Yes, Lordship.
18/9/2024.
Yes, Lordship.
So,
And there is a direction of this honorable court, Lordship, that all the applications for compassionate appointment submitted by the petitioners shall be considered and disposed of by the concerned DLC, SLC on merit by taking into consideration the various guidelines prior to 1/4/2007 laid down by the state government for compassionate appointment and the judgment of the Honorable Supreme Court and the High Court. Consequently, the rejection of all compassionate appointments by the DLC/SLC, which have been put to challenge and are pending in the Guwahati High Court as on 3/4/2025 are set aside. Accordingly, Lordship, as per this order, Lordship, my rejection order of the SLC was also set aside, Lordship. Accordingly, my humble submission is, Lordship, my application may be considered by the SLC.
rejection order was set aside by whom?
By this honorable court, Lordship.
Where? In that matter?
Here it is stated that all compassionate appointment by the DLC, the rejection of all compassionate appointment by the DLC/SLC. My compassionate appointment has been rejected by the SLC, Lordship.
That is the, my lord, he says, my lord, Justice Michael passed this order. That was a consented order. And the Advocate General appeared and they said, what was the discussion, my lord, amicably with both the party. Those who have challenged the, my lord, notification 18/9/2024 and their case is pending before this honorable court, pending before the authority, then a file before 3/4/2025. Those who have filed before 3/4/2005 and challenging the office memorandum 18/9/2004. In that
24.
case, yes, in that case also, court has directed that all the pending case should be considered. Considered means, well, SLC, DLC, whatever may be, like.
Without,
he said
without,
this case is
without interfering with the 2024.
And this case is not covered by this case. This case is filed in 2023. And he has not challenged the office memorandum subsequent 18/9/2024. That's why this case is not covered by this case. That was a consented order, Manu.
As because
Consented
Lordship,
order.
prior to passing of the aforesaid memorandum, my application was rejected. And thereafter we approached this honorable court and honorable court had given us a liberty to challenge that SLC lordship. And in this paragraph, lordship, it is not specifically stated, but nowhere it is mentioned that this is applicable only for those petitioners who have challenged the OM dated 18/19/20.
Otherwise, what is your challenge here?
342, the petition 342, if I remember correctly. These have been mentioned. Last, those who were filed before 3/4/2025, because this order was passed in the month of April 4, right? If I remember correctly. You give me the copy.
Whenever I
What is your challenge here?
Then there's no ground for challenging this.
I only a simple.
No, what is your case in this writ petition?
In this writ petition, lordship,
There was no vacancy. What is wrong?
as because in the 2012.
In view of the consent of the learned council, but all the writ petitions that are pending as on today, 03A,
At present, Debabat Tiwari case has covered this case.
in the Guwahati High Court, which have put to challenge the imprint on are to be treated as follows.
Yes. This is 342, yes, right. 340, writ petition 342, 2025. The Abdul Qadir Bakshi, he is saying like that, Malad, this case specifically said, paragraph 10.
There is no improvement on the impugned or censored by the censor as the same has been made pursuant to judgment of the summit. Without going further into the issue as to whether the aim is spreading down. Has been made by that which is to the effect that all application for compulsory appointment in relation to the which are pending in this court challenging or may shall be considered by the concerned authorities on merit.
Look at this, 342. Paragraph 9 is important.
Yes, these are.
Lordship, kindly see the paragraph 9.
Paragraph 10, you just see.
Yeah, 10 is the operative procedure from 9 ballot. 9
It
says,
shall only apply to cases that are pending before the court, this court, as on 3/03/2025.
yes,
This was pending.
not pending.
Present matter was pending.
It was not filed before.
This case of 2000.
No, he has not put challenge the office memorandum letter, place
That
9
is
lordship
one
policy.
thing.
No, in case of paragraph 9 lordship policy. In view of the consent of the,
All the writ petition that are pending as on today,
yes,
all the writ petition
Pending.
in Guwahati which have put to challenge.
the Guwahati High Court,
Impugn
who is
order
put
8,
to
9,
challenge the
2000 are
impugn
to
office
be
memorandum. That is
decided
the
as
question.
follows. Huh?
Yes, those who have challenged the office memorandum 18/9/2024 and pending before 4/4/2025. But he has not put to challenge this office memorandum. That's why it is not covered. That is the distinction, my lord. Distinguishing those who have challenged the office memorandum, that batch of writ petition, my lord. And filed before 3/4/25. Yes, sir.
What's there? You consider it.
No, my lord, once his case was recommended by the DLC and that was sent to the SLC rejected it. And my lord, so by developer.
What is the ground of rejection?
No, ground of rejection, my lord, there was no vacancy. And now the 24 developer Tibari case has come, says if it is pending for several years, then it should not be considered. Whoever's fault, maybe fault is the part of the petitioner, maybe
That's
fault.
why this court has said, it is also that the deciding application of the reference cannot take recourse to the impunity, though the judgment provided there can be considered applied by the concerned authorities.
Oh, this is the, it
You
shall not,
apply this,
no, my lord, it shall not be a case that pending before the court, it shall not be a precedent.
shall not be precedent, but
yes.
this Debabrata Tiwari's case may be considered by you. On that ground, you reject it again.
Yeah, developer Tiwari, on the basis of developer Tiwari case, office memorandum dated 18/9/2024 were issued by the government. And this office memorandum was put to challenge by those writ petitioners.
I've understood.
Yes. But he has not put to challenge this office of memorandum. He only case is pending because his case is filed before 4/4/2025.
Since you have considering all those cases which was pending and challenging the office memorandum 18/9/2024, since you are considering, you consider this case also.
My lord,
What is saying that you should appoint him or appoint him or her?
No, my lord, because developer Tiwari says, my lord, after passing the Supreme Court developer Tiwari case, this case does not cover this. Developer Tiwari case is applicable.
See, you have rejected her case when? 2017.
17.
He has filed it against that.
And my lord, petitioner died in a harness in 2012. Now more than my lord, 12 to 13 years has gone. So the developer
See,
Tiwari.
you have not considered it.
No, but if it is lordship pass this order, my lord, it will be says, my lord, the developer Tiwari case will be, my lord, has to be, my lord, not given effect to.
See, there is the defense on facts to facts. See, they have applied on time. They
On
filed
time
an
applied,
application.
that part has gone.
You have kept it.
No, that part has gone. He applied on time, that was considered, that was rejected due to want of vacancy. And Achut Das case also there, my lord. Achut Das 2006 says, if it is pending for consideration more than 2 years due to want of vacancy, then no further consideration. Achut Ranjan Das. So in the Devabhat Tiwari case, it is more specifically said, those who were pending for several years, their case should not be taken into consideration.
Not pending.
Yes, he filed it to 23, but his case is pending, my lord, 2012. He come before this honorable court this way.
Lordship,
And this Devabhat
Oh.
Tiwari case is clear.
so whatever, in the said judgment, Lordship, though the issue of the petitioner was the OM dated 18/9/2024, but there is a long hearing. And after this honorable court considers various other aspects also. And after considering all the aspects, Lordship, this honorable court passed this judgment, and therefore, Lordship, in the said judgment, nowhere it is mentioned that it is applicable to the petitioner who has challenged the OM only. It is applicable for all, Lordship.
No, paragraph 9 is clear. Clear.
In paragraph 9, para Roman 1, Lordship, it has been stated that the rejection of all compassionate appointments by the DLC SLC, which have been put to challenge and are pending in the Guwahati High Court as on 3/4/2025 are set aside. Our application was rejected by this
It has
SLC.
to be read along with that. It was, just see, read it together. All writ petition that are pending as on so and the go, which have put to challenge
Yes.
the impugn OM 18/9/2020, because this has been issued pursuant to the Devabhat Tiwari's case.
Yes, yes, Lordship.
So
yes,
these batch of writ petition has put to challenge this office memorandum.
Yes, Lordship.
Therefore, you have
Yes.
to read it conjunctively.
I have gone through, Lordship.
Conjointly you have to read.
Lordship, but during the hearing, Lordship, the
Last
honorable,
it is made clear that the order cannot be used as precedent for cases that are filed on or soon and thereafter. It shall only apply to cases that are pending before the as on so. So this has been read along with this para 9.
yes, Lordship, I have gone through, Lordship.
Therefore, this
you-
is not, I'm just on the consideration that your case is also pending. So
Yes, Lord.
therefore, will not say that this is covered, but then,
My humble
but
submission.
that's why I'm asking, why not
only
consider?
only to consider my application. Thereafter, they decide whatever it is fit for
But
appointment.
what is your, ground in this
Main
writ
ground is
petition?
that in 2012, when my application was sent to the SLC,
Hmm.
it was,
There was a vacancy.
there were vacancy, Lordship,
From
and
where
it
you
has been
get it?
admitted by the department.
Where? From where you get it? First, let us see the rejection. First, let us see the rejection.
Rejection, Lordship, at page 34, Lordship,
Hmm.
of my writ petition, Lordship.
33. Minus of the,
34, Lordship. Yes,
30 yes, where it
34.
is? Which department?
Health, Lordship.
Your name, please.
My name is at page 34, Lordship. In
Rupa
the
Devi.
fourth number of, yes, Lordship, fourth number of box, serial number 3,
Three.
Lordship. Rupa Devi.
Rupa Devi.
Yes, Lordship.
Yes.
So these are the cases of the following candidates were placed before the SLC for consideration, but could not be selected as there is no further vacancies. Further, 2 years have already elapsed from the date of application in their cases, and as no more vacancies available, the SLC, in accordance with the guidelines, decided that their cases will not be considered any further. A speaking order to this effect shall be given by the Health and Family Welfare Department. These candidates are serial number 3 is the petitioner. They are rejected, and this when he is rejected, his writ petition was dismissed. Only liberty is given. You can put challenge this office memorandum, not my notes.
SLC minutes, and accordingly I have challenged, Lordship.
Accordingly, he
What is
challenged
the
it.
ground?
That's why now it's time is not rolling the time, my
Where
lord,
is-
it has come the Devabhat Tiwari case.
Yes, where is the case?
Lordship, we have submitted the application in 1998. Thereafter, the DLC forwarded it in the year of 2012, Lordship.
Hmm.
And in 2012, there was vacancy.
Hmm?
And in 2012, there were vacancies.
Hmm.
And thereafter, we filed writ petition
Hmm.
and SLC in the year 2000, 17 stated that our application has been rejected in the year 2025 due to lack of
15.
vacancy.
Scheme is, my lord, is to tide over the financial crunch. My lord, Development Tribunal says like that, my lord, case, my lord, where the long lapse of time has occurred since the death of the deceased employee, the sense of immediacy for the seeking compensatory appointment would cease to exist. So that is on the basis of that, my lord, this office memorandum was published by the government, and still it is valid. It is not set aside. Office Memorandum 18/9/2024. And Achuranjan case, my lord, does
Will
care.
go into the,
Lordship, at page 20, Lordship,
sir will not go into Achunandan and all.
I have, in page 20, Lordship, it has been specifically stated that there is vacancy, Lordship.
Huh? You are saying will not do, no? With any documents to say?
Yes, Lordship, this is a document. I have annexed it as Annex E, Lordship.
Hmm.
This is a document of the Office of the Joint Director of Health Services, Lordship. This letter is sent to the Deputy Secretary. to the-
Now, problem is in view of this 18/9/2024,
Yes,
how do we direct now?
that is not put to
At
challenge.
that time, Lordship,
That has not been put to challenge. No, the court has not interfered in other proceedings also. It is still holding the field.
Holding the field, my lord, not set aside.
as during 2012, there was vacancy, it has been stated by the Deputy Joint Director that there is vacancy.
You know, I'm
And
trying to
thereafter,
understand.
they did not appoint us, and thereafter in 2015, stated that our application has been rejected only because there is no vacancy, Lordship. And Lordship, my humble submission, Lordship, though this honorable court considered the office memorandum dated 18/9/2024, Lordship, but during the course of hearing, this honorable court considered entire the facts and circumstances of the present situation with respect to the compassionate appointment, Lordship. And only after hearing both the parties, Lordship, this honorable court stated that the rejection of all compassionate appointment by DLC SLC which have been put to the silence and are pending in the Guwahati High Court as on Iman are set aside. Yes, because Lordship,
Court of Tribunal direct consideration of regulation relating to the stalled claim and death.
here it is not stated that the rejection of all compassionate appointments of the present petitioners, it has not been stated, Lordship. Yes, because Lordship, my only humble submission is, Lordship, my application may be considered.
Sir, why trying to understand 18/9/2004 has come into force?
Yes,
And
Lordship.
you have not challenged that. And
Yes.
those, in earlier proceeding, this was challenged, but it has not been interfered with.
Prior to.
And this is
my-
only the
my-
concession,
My petition was not
this
rejected.
is an consent order.
My petition is not rejected with respect to the OM dated 18/9/2024, Lordship. Prior to it.
See, that is the
Prior
office
to-
memorandum holding the field now.
Yes, Lordship.
Suppose if we say that you may be allowed to, you can be considered, then under what provision? This office, it will be based on office memorandum only.
May I read a one?
And
page?
by
Yes,
this,
Lordship.
all this, the policy scheme has been done away.
Yes, Lordship.
If it is
Though-
yes, then nothing remains.
Though those cases were, the petitioner filed those cases, Lordship, challenged the OM. But I beg to reiterate, Lordship, after considering all the facts and circumstances as on today, with respect to the compassionate appointment, Lordship.
Hmm.
This honorable court rejected all the compassionate, rejection of all the compassionate appointment by the DLC or SLC, which have been put to challenge. We have put challenge that, Lordship. And at that time, before, on the date of 3/4/2025, our writ petition was pending, Lordship. This, as per this paragraph, Lordship, my writ petition is fully hit, Lordship. That's why my humble submission is only to consider my application once, Lordship.
So may I reading the,
And it has been also stated that
our
this
High Court
petition
has-
should be considered within 6 months, Lordship.
our High Court had passed dismissing the authority, I am reading it, paragraph 19.
Which
case,
one?
I would give the citation, just I am citing, saying the contention. From the approached authorities, it is clear as crystal that even if the court or tribunal directs to consideration of representation relating to a stall claim or debt grievance, it does not give rise to a fresh course of action. The debt course of action cannot raise like a phonics. Similarly, a mere submission of representation to the competent authority.
That is completely different.
I will provide it, my lord.
No, I don't want that. That is completely different. This
No.
is now, we are on the interpretation of this, how this can be made applicable or not, that you have submitted already. According to him, this order has to be read that it has to be construed that since his case was pending as on 03/04/2025, he should also be
But-
given the similar, provided similar relief. But
he
prima facie, I find that it has to be read in conjunction with the 9 and 10. It has to be read conjoint.
But he has not put this office paper will still continue, my lord, holding.
Sir, I have understood, I have heard you. Dispose of, heard Mr. So-and-so, learned counsel for the petitioner. And also heard Mr. T.C. Chutia, learned additional senior company advocate for all the respondents.
Order.
I'm appearing for the health department.
Health department. Yes. So what do you say?
But we don't have to say anything. Because it is-
You will have to say,
It's the decision of the state level committee, madam.
no, on law point, this is why they're trying to interpret the law.
But we have to forward the application only. We
I
have
mean,
forwarded the application to
not
the-
interpret, we are trying to understand the law, Devabrata theory and all those judgment which rendered by the coordinated bench. He had different interpretation that he said this is covered by, it's covered his case, he said it's not covered. What do you say?
It's not covered, my lord. because,
Why?
He has not put the.
Suppose today you are not an standing council health department.
Yes, ma'am.
If amicus, what do you say? What would you say?
Because 18
Amicus.
24 notification he has not challenged. On the
Hmm.
basis of that notification, my lord, he is not entitled. my lord.
Hmm. But then in those cases,
Yes, my lord.
court has set aside all the rejection by the DLC and HLC. For it is for those particular,
That notification.
that is there, but then the rejection irrespective of on what ground it has been set aside.
My lord, without deciding.
I am
on
not
the-
saying that it is directly, covered, but in the light of this, why don't you consider his case also? Because there was a cases where all the DLC and SLC has rejected their claim of the petitioner in those cases also. Right. I'm not saying that this is automatically applicable. What I'm saying, in the light of this, when you have given already concession on a few who have challenged that new office memorandum, although he is not challenged.
That is consented.
But
order,
they,
my lord.
ultimately, what was the issue? The issue, grievance was against the rejection by the DLC or the SLC.
That concession.
So ultimately, you have to consider that.
That concession has been granted by the honorable court, my lord.
Not this honorable. On the concession, on the consent of the Advocate
the
General
parties
and the
agree.
lawyers.
To have on, to challenge that notification, my lord.
And pending before 3/4.
That's what I'm saying. That's why I'm saying it's applied. I'm not saying in the light of this, when the consideration is against the rejection by the DLC or SLC, irrespective on what grounds, reconsideration has been directed. Of the few of the petitioners therein, why not consider his case also? That is what I'm.
Hello, what is the purpose of the scheme, my lord? To read about the certain, my lord.
Sir,
immediate-
what about your concession in this
My
matter again?
concession is there, my lord, because office memorandum is there, he is still holding the field. As per the office.
See,
memorandum,
what is the ultimately what you have to consider?
we will have.
Rejection only. Rejection and of the by the DLC and SLC. You are not considering on the basis of the OM.
No, my lord, what I am saying, my lord, if your lordship direct to consider this case, then each my lord, that other case will be come in, it will be floodgate, because 342.
See,
this,
if
writ
you can
petition
consider,
order is
if you can
standard order.
consider a few, why not, you cannot consider as a state,
No, this
those
is,
equally
facts is different, my lord.
irrespective of technical, thing.
No, no, I understand fully what lordship want to say, but we are, my lord, constant to say, because, my lord, this office member is holding the field, at this stage, my lord, we cannot say, lordship will direct them to consider his case again after passing of this order in writ petition 342, 2024. The 342, before your lordship, this case, my lord, says those who were challenging the office memorandum 89, 2024 and pending before April
Back to-
3/4.
To square again.
That is
You're back to square again. Anyway, I'll see.
obliged.
Okay, na? लिख लिया नहीं लिखा है recorded. Present लिख से. Your name, please?
UB Sharma, Lordship.
I heard Mr. UB Sharma, learned counsel for the petitioner, and also heard Mr. TC Chuti, learned additional senior government advocate
2 and 3, my lord.
for respondent 2 and 3, and
And
Mr.
Mr. Bora is for 1, 4, 5 and 6.
DP Bora,
Yes.
DP Bora, then standing counsel health and family welfare department for respondent number
1,
1, 4,
5,
5.
and 6.
I'll pass down.
Dispose of, my lord. Obliged, lordship.
It's not possible.
Obliged.
I think, sir, today it's not possible.
No, it will take time. Your lordship may give a date,
January.
fixed date. January will be too late. He has been.
Because next week too, definitely, in fact, we have fixed so many matters, and as the tradition is, and the practice is, last 2 weeks will be only motion days.
Sunday, yes, my lord.
So, difficult. And fixing
January,
would not be,
8 or
even if we fix also, it will not be able to take up.
8 January.
Due to paucity of time, the matter could not be taken up. Mr. B.D. Das Lanu Senior Counsel so and so, assisted by so and so, assisted by Mr. And and Mr. So and so are present. As agreed to by Lanu Council for the party that this matter be listed on 8. Possible? 08. 01/20/26. No, we have kept it already concluded. And we'll be recording that despite sufficient opportunities, the government has failed to produce the record. The junior who was appearing on, I told, she agreed, happily agreed. It should be recorded. Yes.
Item 32.
Lordship, in this case, your lordship, we have some urgency in the sense. Your
Yes,
lordship-
what to do?
Lordship, if it can be fixed on.
What is this?
This is your lordship pay regarding pay parity, your lordship.
Where is the urgency there?
Urgency in the sense, your lordship, the next pay commission, they have already declared, the government has declared its intention to form the next pay commission, your lordship. And
When?
A few days back, your lordship.
So?
Now, once it, your lordship, pay commission starts functioning, your lordship. The
You file a representation.
No, your lordship, the base will be our present salary. That's why your lordship may fix it on 16th, your lordship. You
No,
may
it's-
take a
I
chance,
think
your
it's
lordship.
not possible.
If your lordship not possible, like if somehow your lordship
Yes,
can be on 16th, your lordship.
but
If it is
may
not,
not be possible.
if it is not.
I think
take-
16 we have picked so many matters. Because it's of no use fixing it. Why not try in the new year?
Then your lordship on 14, your lordship.
14, huh? 14 January.
No, your lordship, in the month of December, your lordship.
Very difficult.
Before vacation, your lordship.
Then
16 or
16.
15 or 16, probably a Sunday. 16 it can be
Make it
taken up.
16.
We
But
want-
chances are,
Lordship, we want to just take a chance if
Ah.
it is not listed and not reached, then
same order, due to paucity of time, it will be taken up for hearing. List of. Enough, huh? Mr.
S. Borthakur.
S. Borthakur, Learned Council for Petitioner L.
I'm A. Fukan for respond number 1.
And
I'm for finance.
HLA. So, are present, as agreed to by parties, let this matter listed on 16,
Lordship,
12,
deeply
20,
object.
25. Same order, what's the? Same order,
Yes, your lordship.
or are you ready? Is a short matter what?
No, your lordship, it will take some time and I'm led by K. N. Chaudhary, senior
Okay,
advocate in this
then
case.
in that case.
I am for only my lord, respond number
During-
4.
So in same order.
Obliged.
Associate.
I am for, I am for respond number 4 only. TCS with you.
After 3 weeks, 4 weeks.
Oh, yes, your lordship.